Good morning, everybody. Welcome to the Joint Ag Committee meeting. We're going to start our meeting this morning with a Pledge of Allegiance, and then we'll call roll and get started with our meeting. You want to lead us in the pledge, Representative Conrad?
I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Katie, would you please call the roll?
Good morning, Mr. Chairman. This is roll call for October 30th, 2023. Senator French.
Here.
Senator Hicks.
Excused.
Senator Ide.
here.
Senator Kolb.
Present.
Senator Larson.
Here.
Representative Allemand.
Present.
Representative Allred.
Here.
Representative Banks.
Here.
Representative Conrad.
Here.
Representative Davis.
Here. Here.
Representative Slagle.
Present.
Representative Winter.
Here.
Chairman Eklund.
Excused.
Chairman Steinmetz. Here. Vice Chairman Crago.
Here.
We have a quorum.
All right, so before we get started, just a reminder that all of our legislative meetings have rules of decorum. There should be a copy of that at the front door if you have any questions on what that looks like. Mostly that means address all your comments through the chair. When responding to questions from the committee, do that through the chair. Also keep your comments on the topic that we're addressing at the time, and always be courteous to the folks up here and to the folks online. So with that, I think we'll get started with our first topic, which is eminent domain, and I believe LSO is going to get us started on that.
Good morning, Mr. Chairman, members of the committee. Would you like me to go over the memo or just the?
I would. Let's start with the memo first, and then we'll dig into the bills.
Okay, and do you want me to go through both bills or one at a time?
Let's do one at a time. I think that'd be the easiest to start with, and then if we may end up discussing some of them together, but if you
Okay.
just go through them one at a time. Thank you.
Okay, thank you. All right, members of the committee, you should have a memorandum entitled Eminent Domain Case Law in front of you. The Wyoming Eminent Domain Act addresses in part the ability of private entities to use the power of eminent domain to condemn the property of other landowners. Wyoming statute appears to give private entities the right to use eminent domain proceedings to condemn the land of others for the purpose of developing transmission lines for energy collector systems. Before resorting to condemnation, private entities have to attempt to negotiate with landowners, and in order to utilize the power of eminent domain, the property acquired must be put to a public use or necessity. Private entities must only show a reasonable necessity for the project, and the entire community need not be benefited by it. The measure of compensation for a taking of property is the fair market value as of the date of valuation, and then Wyoming statute 126.704 gives an overview of how fair market value is determined, and that's laid out in the memorandum. Fair market value and comparable sales must be based upon an arm's length transaction between willing buyers and willing sellers, and prices paid in condemnation actions or under actual threat of condemnation are not admissible as comparable sales. Under a partial taking, a landowner is entitled to prove the value of the property rights taken. The measure of compensation is the greater of those alternative amounts. And then if negotiations fail and the landowner rejects the condemner's offer of compensation, a condemnation proceeding in the court system will commence where the landowner has to prove just compensation. At that time, 3 disinterested appraisers will appraise the property in question and must determine just compensation for the landowner. If after this, the compensation amount is still in question, the issue of compensation goes to a jury. After compensation has been determined, the court will enter an order granting easement to the condemner. And then the court has broad authority in how compensation will be awarded to the condemnee, such as in a lump sum amount or annual payments. And that's pretty much the entire memo in summary. And I would take any questions.
Any questions from the committee for Anna? So I have one. In your memo, you talk about the public use and necessity and that's set forth in 126-504.
Mhm.
How does that interplay specifically with our constitution and the provisions within the constitution pertaining to eminent domain?
I don't know, Mr. Chairman, I don't necessarily know that I can answer that question. I'm not entirely positive.
Okay, thank you. Any other questions? All right, let's move on to the first bill.
Okay.
Which is 113.
Oh.
Oh. Representative Davis, so if you could raise your little Zoom hand, we'd see you better. But go ahead. Thank you.
Mr. Chairman, my little Zoom hand is raised according to my computer, but anyway, I had one question there. When we're coming up with the fair market value to be determined for that landowner, is that based on, I guess my question would be, the energy that we're generating through this eminent domain taking the in place where that energy is being mandated green, say for instance, California or something like that. Are we basing our fair market analysis on the end or at the beginning where the energy is produced? Does that have any bearing on that?
Anna?
Mr. Chairman, Representative Davis, it's based on the fair market value at the time of valuation. So at that time, whatever the fair market value is of the property.
Okay, to
Follow up,
Mr. Chairman.
yes, sir.
Yes, there's a lot of different in value in property at the California level as to the Wyoming level. So if we're basing this taking of energy on property values, would it be best to go to the end where the higher values of the property are as opposed to the lower ag values of the property on this end? I'm just looking at the fair market analysis.
Mr. Chairman, as it's laid out right now in statute, I mean, it's just based on the actual valuation at the time. I suppose that would be a question for the committee whether or not they'd want to change that, but if I understand the question correctly.
So I'll chime in here just for a second on it. So I think the question is, should we be using California values to determine compensation on Wyoming land? Is that correct, Representative Davis?
Yes, Mr. Chairman, because the end product is where that energy is going. So that energy is where it's being sold. You know, I guess is my question. The fair market value for that energy should be based upon the end product, not the beginning or the taking, the gathering.
So let me ask this question, Representative Davis, just as a follow-up to Anna. So are you aware of any case law or precedent or laws from other states that do that or utilize that system to establish just compensation?
Mr. Chairman, no.
Okay. Thank you. Any other questions for Anna? Any follow-up, Representative Davis?
No, thank you, Mr. Chairman.
All right, good. Let's move on to the bills.
Mr. Chairman, members of the committee, I'm going to start with LSO 24 LSO 113, which is eminent domain energy collector systems. On the beginning of page 2, this bill draft creates a new Wyoming statute 126-715. It states the compensation related to the condemnation of property for the erection, placement, or expansion of a collector system associated with the commercial facility generating electricity shall be made in accordance with the new Wyoming statute 126-818, and that begins on the middle of page 2. It states that no person other than a public utility that has been granted a certificate of public convenience and necessity shall be granted the authority to condemn property for the erection, placement, or expansion of a collector system associated with the commercial facility generating electricity without complying with this section. Before a person may exercise the power of eminent domain, the person shall negotiate and have finalized land use and compensation agreements which shall grant the person the right to occupy and use not less than 85% of the land on which the collector system will be constructed, or negotiate with not less than 85% of the owners of the land which the collector system will be constructed if there are more than 2 landowners involved in the potential condemnation action. The person shall also provide proof to a court of compliance with those negotiations, and provide proof to the court of all terms and consideration, monetary and otherwise, granted to the owners of property with whom the person negotiated. The person shall also provide proof to the court that the commercial facility generating electricity with which the collector system is associated constitutes an economically, legally, and logistically viable project. In any condemnation under this section, the person whose land will be condemned shall be compensated with consideration that is equivalent to the average consideration given to the other landowners upon which the collector system will be constructed, or if there are 2 or less landowners, that is equivalent to the fair market value of the land that is to be condemned. A commercial facility generating electricity shall not use an existing easement to place additional collector systems without first complying with this section. And this section does not apply to a public utility that has been granted a certificate of public convenience or necessity, or an electric substation or interconnection facility associated with existing or proposed transmission lines that serve load or that export energy from Wyoming. This bill draft gives the definition of collector system associated with the commercial facility generating electricity, as well as commercial facility generating electricity. And then section 2 provides conforming amendments. It also provides an amendment to 126.815 by creating a new subsection E. That subsection requires that condemnation under that section shall not occur unless the entity is a public utility that has been granted a certificate of public convenience and necessity, or except as provided by the new Wyoming statute 126.818. Section 3 repeals 126.815D. And section 4 is an applicability section where this act applies to eminent domain actions initiated on or after the effective date of this act. And then section 5 provides an effective date, and that's the entirety of the bill.
Thank you, Anna. Any questions from the committee regarding this particular bill draft? Madam Co-Chairman.
Thank you, Mr. Chairman. Anna, could you just take us through what 126.815D says, just for the repealer's sake? Thank you.
So yes, Mr. Chairman, Madam Chairman. 126.815D basically deals with wind energy, and it's actually outlined in 126 in 24 LSO 123. It's actually there in its entirety if you'd like to read that over, but it deals with eminent domain as it relates to wind energy collector systems.
Any follow-up? All right, Representative Conrad.
Mr. Chairman, thank you. On your question, a question for you on the beginning of page 6, specifically as it relates to lines 1, 2, 3, 4, and 5. And this is probably a clarifying question for myself specifically, but it does state in the last, in this case, lines 4 and 5, that serve load or that export energy from Wyoming. So my question, and it's probably my clarifying question again, is this applicable if those service lines or collector systems serve Wyoming and are not exported outside of Wyoming?
Well, the actual bill draft, well, that serve load, I think would involve would involve collector systems within Wyoming, from what I understand.
Okay, so
Follow up.
Thank you, Mr. Chairman. So I think you answered my question, but just to clarify, this includes both production or transmission in and imported or in state and out of state. Is that correct?
I believe so, yes.
Thank you.
There's probably some people in the audience who'd be able to better answer that, but
Okay.
yes, I believe so.
Thank you.
Any other questions? Representative Slagle.
Thank you, Mr. Chair. One question for you on kind of on that similar line. It looks to me, when I read this legislation, it talks about this section shall not apply to. So it doesn't apply to anybody that's exporting energy from Wyoming. Is that what these lines that Representative Conrad addressed?
Yes, on line 4 and 5 on page 6, that serve loader that export energy from Wyoming, yes.
Okay, so in other words, we get somebody comes in and builds a wind collector system or solar system, and then they're exporting that from Wyoming, then our eminent domain statute here doesn't apply to them.
I don't believe so, no, not by the way that that this new statute's written.
Yeah, thank you.
Any more questions on this bill draft? Senator Cole.
Thank you, Mr. Chairman. Just a general question about the 85%. Where did that come from and why was that number used as opposed to some other number, 2/3 or whatever it may be? Could you please help me with that?
Mr. Chairman, Senator Kolb, that was taken from the model legislation that I was given at the beginning at our June meeting. I'm not entirely sure where the 85% came from, but apparently that was a good number for what they considered to be necessary to have an eminent domain action for this particular legislation. I think there's probably people in the audience who'd better be able to answer that question.
Senator Ide.
Thank you, Mr. Chairman. This is probably something that you may not be able to answer on page 6, line 7, where it describes commercial facility generating electricity. How do you quantify a commercial facility if it's getting taxpayer subsidies? And in my estimation, it wouldn't be commercial if it took taxpayer money to be viable. Can you comment or give an explanation to that? Thank you.
Mr. Chairman, Senator Ide, you might want to have an amendment clarifying that in the definition, just to clear that up. But that's a committee decision.
Any more questions? Representative Davis, I see you have your little hand up. Good job.
Thank you, Mr. Chairman. May I be so bold as on page 4, number 4, line 5. Could we put under there after legally and the legitimate, whatever, and viable project, could we put on there for the state of Wyoming for use within the state of Wyoming? Would that kind of clarify some stuff there?
Anna?
Mr. Chairman, Representative Davis, I don't necessarily know that it would be a committee decision whether or not to only include energy that would be used by Wyoming, but I think that might create too much of a that might narrow the scope a little bit more than the committee would wish, is what I'm thinking, but that's definitely a committee decision.
And that would be likely a policy choice.
Yeah, it'd be a policy choice.
Okay. Thank you. Anything else on this particular bill? Any follow-up, Representative Davis?
No, thank you, Mr. Chairman.
All right, if we don't have any more questions on this bill, let's move to the next one, Anna, please.
Okay, that's fine. And Mr. Chairman, members of the committee, this next bill is 24 LSO 123, Eminent Domain Energy Collector System Amendments. This bill draft removes reference to wind energy throughout Wyoming Statute 126.815D. It makes the subsection applicable to all collector systems associated with commercial facilities generating electricity. And it also states that no person except a public utility that has been granted a certificate of public convenience and necessity shall exercise the condemnation authority granted by the section. It also provides a commercial facility generating electricity. It also prohibits a commercial facility generating electricity from using an existing easement to place additional collector systems associated with the commercial facility generating electricity. Section 2 is an applicability section, and Section 3 provides an effective date. And just so the committee is aware, this first bill draft 113 actually repeals 126.815D, so it might be a good idea to pick one or the other. rather than going forward with both of these bills because 126.815D or would be repealed by 113, just so you're aware. And I would stand for any questions.
Yeah, thank you, Anna. Any questions on this particular bill draft from the committee? All righty, think you're good to go. Thank you.
Okay, thank you.
We'll roll into public comment. Is there any state agencies in the room that would like to comment? All right, seeing none, let's move on to general public comment that's here with us today. If there is any, gather around the mics up here. A couple of you can come up at a time and we'll get started. Please introduce yourself for us. Thank you.
Good morning, Mr. Chair, members of the committee. My name is Jeff Pope. I'm a partner with the law firm of Holland and Hart in the Cheyenne office. I'm here today on behalf of the American Clean Power Association to speak in opposition to both of the proposed bills that were just covered. I have with me another partner in the Cheyenne office, Isaac Sutphin, who is going to speak as well. I'm up here first because I straddle both of the interests that these bills are dealing with. I have done a fair amount of condemnation work in my practice. In fact, the most recent condemnation decision, I was involved in arguing that case. I also head up our industrial siting practice, which means I help permit renewables projects and other projects that fall under the purview of the Industrial Siting Act. So I have communications with the renewable sector here in the state. Let me start with this as a big picture item. This strikes both the American Clean Power Association and the renewables companies that I work with as a solution in search of a problem. I think we can all agree that good public policy is grounded in data. That's why y'all have these meetings. That's why you have folks come talk to you. I can represent to you that no renewable company has ever condemned any property in the state of Wyoming. In fact, when they ask me to brief them on the law for condemnation, it's always couched with, we don't ever want to have you do this. And so my clients, when they got wind of this bill and the American Clean Power Association had all had the same question. Why are we doing this? Because the net effect of these proposed bills is to remove the ability of a private company who is building a collector system, which is now just not wind. It would apply to solar and argue it would be applicable to nuclear companies who are coming into the state of Wyoming. You can think of Terra Power. You can think of some of the other small modular reactor companies that are looking at locating in the state would be affected by this legislation. And for those clients of mine, in asking why, they wonder why, because they come to Wyoming in part because of its business-friendly atmosphere. We obviously have a favorable tax structure, but they also find people at the county level, at the local level, who are willing to work with them. They find landowners who want to develop these types of projects on their land. And so they wonder why. Why are they being targeted? And in particular, and perhaps the most problematic language that they have flagged, and the primary reason I'm here, and I'll use the bill draft 24 LSO-0123, and the language is on page 3, lines 1 through 4, where it says a commercial facility generating electricity shall not use an existing easement to place additional collector systems associated with the commercial facility generating electricity. The reason that this language is incredibly problematic is it takes vested private property rights, i.e. I as a developer or commercial facility have already executed a document with the landowner granting me an easement that allows me to construct collector systems or other infrastructure on a piece of property. This bill, and the same language is in the other bill draft as well, would strip the ability for me to locate and construct that infrastructure. And particularly problematic is if I haven't built any infrastructure, but I've signed up an easement, which is typically how it goes. You lock down your land control before you do any permitting work and before you build anything. This language would remove the ability for that company to build anything. So it would not just be applicable in a scenario where there's existing infrastructure. It would apply where there is none and you seek to construct. Now, my colleague and I were joking on the way over that kind of language would be great for us. I could put my kids through college with all of the inverse condemnation and takings cases I would be able to bring on behalf of my clients. But on behalf of the state, I don't think that's a very good idea to have lawyers in the courtroom seeking hundreds of millions or billions of dollars in damages from the state of Wyoming. And I don't throw those numbers out to try to scare anybody. That is the realistic valuation of these projects. There's huge capital construction costs with wind or solar. And if y'all are curious, as part of the industrial siting process, these companies are required to provide the material construction costs and the financial valuations of their projects. So they're a matter of public record. I'll give you the last solar project I did was the Dino Solar project, which will be built just outside of Casper. That project has a material construction cost of about $1.2 billion and has a project valuation north of $2 billion. And in a world where they can no longer build a collector system to get their electricity to market, that project valuation probably goes to near zero. And I would suspect there would be legal action as a result of that. So I would encourage that language at a minimum to be stripped out. It represents a threat to the viability of these projects and real likelihood of litigation. And I should also note for the committee that it's not just the companies that would be concerned about this. The landowners who have executed easements, who have allowed these projects to be built, actually want these projects. And I'll give you a recent example. I represented the Two Rivers wind project before the Carbon County Commissioners about 4 or 5 months ago, getting a conditional use permit. And not only were there folks from the company there testifying on behalf of that project, but the ranch owners themselves who were going to be the landowners for the project were there in strong support. It represents a real revenue source for them, and they advocated on behalf of it. But now these projects suddenly become less and less viable in a world where this type of legislation exists that strip the ability to build on existing easements. I also wanted to mention something about a few of the questions about Wyoming energy versus non-Wyoming energy that was raised. And unfortunately, I'm going to get into the legal weeds. So if y'all go to sleep, I understand. That attempt to make a distinction between things leaving Wyoming, things staying in Wyoming, represent a dormant commerce clause problem. The dormant commerce clause, if you don't know what that is, it's sort of the inverse of the federal government's authority to regulate interstate commerce. The U.S. Supreme Court has found that when states attempt to restrict commerce in a way that distinguishes between that state and out of state in a way that unfairly burdens, and I might be getting that language slightly incorrect, but burdens out of state commerce in a way that would impede the federal government's ability to regulate, you have violated what the Supreme Court calls the dormant commerce clause. So it's another sort of trap that is out there for this legislation. A few other things that, as you consider this legislation, I think are important to keep in mind. The first is the legislation empowers public utilities to condemn for wind energy collection systems. The way the marketplace works right now is private, non-public utilities tend to develop these projects, renewables projects, in 2 stages. The first is smaller development companies come in, they acquire the land use rights, they lock down some aspects of the project that are necessary for permitting. And sometimes they will take a project through industrial siting or through the county permitting process. And then they will sell to another larger developer. an off-taker. Think of a Nextera Energy, for example. They will acquire a project from these smaller developers. And then they will do one of two things. They will either develop and operate the project, or they will develop the project to a certain extent, and then they may sell to a public utility like Rocky Mountain Power, who is looking for this type of energy for the portfolio standards that it has created. The net effect of shifting condemnation authority out of the hands of private developers and into public utilities' hands exclusively would be that development process changes. Where now, if you have a landowner who is necessary for the collector system, but doesn't want to sign up for it, you then have to get the public utility involved, and you force the sale to the public utility probably far earlier in the development process. May not seem like a bad thing, but here's where it might be. You all are aware of the rate case going on in front of the Public Services Commission on dealing with Rocky Mountain Power's rate increase. A world in which those public utilities are now having to buy up, or the risk management profile for these projects requires some public utility involvement, may add fuel to the fire for we need rate increases, because now there's additional costs associated with the development of the projects in the public utility portfolio. Now let me end. I'm going to take off my American Clean Power hat for just a second, and I'm just going to put on my citizen hat, and then I will be quiet. One of the things that strikes me about this legislation as a citizen that is very concerning, as a Republican, I should say, as a registered Republican, it doesn't seem very Republican. And let me tell you what I mean by that. The net effect of shifting who has the power to condemn, or shifting how compensation is awarded such that it's much more expensive to go through the condemnation process, is in effect picking a winner and a loser. Government shouldn't be doing that. Ronald Reagan was famous for saying the scariest 9 words you can hear: I'm from the government and I'm here to help. In effect, what we're doing is attempting to put our thumb on the scale and try to get renewables out of the state of Wyoming. And I'm not here to have a debate about whether renewables are good and bad. Personally, I've represented oil and gas companies, coal companies, renewables companies. This is much more a philosophical question about, should the Wyoming legislature be wading into what industry should succeed or not succeed in the state of Wyoming? And I'd ask you all to think about it in this context. The Rock Springs Resource Management Plan that the BLM has proposed is very much putting its thumb on the scale, except different industry. Oil and gas would be dramatically affected if that proposed plan goes through. And it's faced a lot of opposition for a lot of logical reasons. The same thing is true. We're all frustrated with the federal government and EPA regulations and what those have done to oil and gas and coal. This is just our version on the opposite side. And I know I'm probably running a little late, and maybe hear the music to get me off. So I would simply close with this. There is not a condemnation problem for renewables or companies that are looking to build collection systems in the state of Wyoming. They don't want to, they've never had to. But in a world where we pass legislation that strips them of those private property rights, we simply invite litigation. Good for me, probably not good for the state. I'd stand for any questions.
Thank you, Mr. Pope. Is there any questions for Mr. Pope? Senator Cole.
Yeah, thank you, Mr. Chairman. I guess on the comment that you had made about the commercial facilities generating electricity shall not use existing easements. On that particular question, do you think it's fair that you have an existing easement that was agreed to at one point in time that cost, it was given X amount of dollars for compensation, and then the easement is actually utilized to a higher level in the future? And so it basically did not follow the original conception of the easement need. And should there be more compensation given, perhaps, because of the expansion of the use of that said easement? What's your opinion about that, sir?
Mr. Pope.
Mr. Chairman, Senator Kolb, my opinion would be that would be illegal. The language that controls an easement is what both the grantor and the grantee have to follow. In a world where the company that seeks to build a collector system exceeds the scope of the easement or overburdens the easement, they would be subject to a lawsuit. In fact, I've had to bring those types of lawsuits. There would be existing legal protection. And I think the net result of that scenario would be that whatever company is seeking to expand its collector system would need to go back and renegotiate the easement to either provide more compensation to deal with the additional burden on that easement, or to negotiate additional language that would allow for the whatever the expansion was that company was seeking.
Follow up. Yeah, thank you, Mr. Chairman. Well, I guess I'm a little confused because, they go through a negotiation process for an easement. And that apparently is an easement for absolutely anything that followed the first use of the easement. Say it's a power line. So they could put anything on there that fit within that easement. Is that what you're saying?
Mr. Pope.
Mr. Chairman, Senator Kolb, no, what I'm saying is when you sign an easement, there are terms in that document that will control what you can and what you cannot do within whatever the space of that easement is. And there is a point at which you may do some things in that easement which were, you could say, not contemplated or are just not consistent with the language of that document. And in which case you have overburdened that easement. And I'll give you an example from some litigation I've done. An easement was granted to a water district to allow access, just road access up to a site valve. And at a certain point, the water district began accessing for the purpose of constructing brand new facilities. And so now it wasn't just one truck every month, it was construction crews every day coming up and down this road. That was an instance of overburdening the easement. And there was, at least in that instance, the threat of litigation. What happened was there was a new easement negotiated that provided for expanded rights for the water district, but also additional compensation for the landowner.
Follow up.
Yeah, thank you, Mr. Chairman. Yeah, then I guess thank you for trying to explain that. Next was the Republican comment you made about things being Republican or not Republican. I'd like to ask you a question. Do you think the federal government subsidizing projects that wouldn't be fiscally viable is in fact not putting their finger on the scales of economic development? Because without government subsidies, they wouldn't exist. You wouldn't have a lot of these green energy projects. I would fathom to say you wouldn't have any of them without a government subsidy. So I think, would you agree or disagree that that is the federal government putting their thumb on the balanced scales of economic development or projects?
Mr. Pope.
Mr. Chair, Senator Cole, as a general matter, yes, I would agree. The use of tax subsidies or tax credits to take a project that would not be economically viable in a world of pure fair market competition is absolutely putting our thumb on the scale. Unfortunately, we have hundreds of years of federal and state governments doing that. But I would caution that it's sort of two wrongs don't make a right. I get it. And I have clients who the reason they build these projects is the Inflation Reduction Act threw tons of money at these projects. And in fact, the tax credits for some of these companies is worth more than the actual project. As a free market economist, I personally have trouble with that. But what I am suggesting to the committee is that the reaction of the state of Wyoming should not be the federal government made a bad tax decision, so we're going to try to stop you from coming here and being a part of our business community. I think that's a question for our federal delegation to address, but I agree that subsidies, tax credits distort what should happen in a free market.
Senator French.
Thank you, Mr. Chairman. Sir, help me out a little more on this 123 that we've been talking about. Like page 3, the commercial facility generating electric shall not use an existing easement. Why can't they, for the collector system, why can't they negotiate an additional easement alongside the other one Apparently that's not an issue because you've said eminent domains never used. So what's the problem with negotiating another easement for those collector systems? Thank you.
Mr. Pope.
Mr. Chair, Senator French, I think you could encounter a scenario where someone simply negotiates a new easement. The larger concern with the language that appears on page 3, lines 1 through 5 of 24 LSO-123 is that it would, let me give you a scenario. I'm a wind, solar, somebody who's going to build a wind energy, or excuse me, an energy collector system. I've executed an easement with a landowner that says you have the right to build an energy collector system on my property. You have that easement right, but I haven't built it yet, either because I'm going through the permitting process before I build that, I'm getting financing, whatever it is. The language as it exists here would say, I can no longer build because I have not built anything on that easement. I'm going to build something that is an expansion of an existing easement. Now, it's possible that the drafters of this legislation didn't intend that result, but that is some of the mischief that I have concern about that could arise from that. So the scenario of I've already built on an existing easement, chances are you're probably not going to need another easement because you've built your transmission line already. This is more of a concern about, I don't have anything there. I want to build, but now I can't.
Follow up.
Thank you, Mr. Chairman. But you were just talking about if you have an existing easement, you can, that describes, okay, I can put a collector system on it, blah, blah, blah. That's good. That's a good easement. So I don't understand what you're saying there, that if you haven't built it, but in the negotiation with the landowner for that easement, because I've done easements, it described in there, this is for a collector system that may be built in the future, whatever that exists, that easement you negotiate is good. So I don't get where you're coming from. Yeah, if they have one that's in place for the, let's say the windmills or the solar, and then you got to do this collector that doesn't have that easement, and you negotiate another easement for that easement's good. I think we're getting a little, like you say, in the weeds. We're way out in the weeds here. So help me out with that. Thank you.
Mr. Pope.
Mr. Chairman, Senator French. So this is probably the lawyer in me that's got y'all wrapped around the axle. So if we look at lines 1 through 5 on 123, it says the commercial facility generating electricity shall not use an existing easement to place additional collector systems associated with the commercial facility generating electricity. The concern I'm talking about is where you execute an easement, therefore it's an existing easement, but you have yet to build a collector system, which is what happens all the time in the development process, because you can't build a collector system without getting a permit. You can't get a permit without first having site control. And the primary mechanism of site control is some kind of an easement. You call it an easement, you call it a surface use agreement, whatever you call it. And I understand from the reaction that I get that the intent here may not be to say, oh, you haven't built anything, now you can't. I get that may not be what y'all are trying to do, but it is the language of the bill that would allow someone who wanted that result to argue for it, because they could say this: you have an existing easement. There are 0 collector systems located on that easement. You are now attempting to build, after the effective date of this act, a collector system. This language bans that. Now, a court may say, oh no, that's not what that language means, but a court could say, yeah, that's the plain language of what that legislation says. So I certainly, if there's a desire to clarify so that is not a scenario we encounter, I think the American Clean Power Association would be in favor of such a result. But my concern is, as it's currently drafted, it invites some of that mischief.
Senator Kolb.
Thank you, Mr. Chairman. I think I understand more what you're concerned about. I think the light that I'm looking at this in, though, the intent that I think this is trying to get to is saying that somebody who has an existing easement can't just be run over by another company that comes in with another project and expands said use of said easement. So I think maybe what would be your opinion about removing the shall or put down some language that would without a new agreement or, having the ability to not restrict it, because I think, frankly, I see what you're saying. Now, my thought is what can we do to protect people with easements that are, frankly, I'll just say, being abused by a new situation coming in where they're using it in a way that it never was originally talked about or agreed to. And so that's the backstop that I think they were trying to get after here. What's your opinion about being, I guess, as I've been told by other people running committees, that if you come with a problem, you should come with a solution. So what are your thoughts on that?
Mr. Pope.
Mr. Chairman, Senator Cole, I'll give you two potential solutions. Now understanding that the goal is to prevent essentially someone from taking and abusing the language in an existing easement. The first solution, and I'm guessing it's going to be an unpopular solution, would be to do nothing, to take this language completely out of this legislation. The reason I say do nothing is because the law already protects that particular individual. That particular individual can hire a lawyer and sue and say, you have exceeded the boundaries of the language in the easement. You are doing things that are not allowed. And courts can say, yep, that's true. And either you pay damages or there can be other potential remedies. So that protection exists. And I will tell you that's the preferred remedy for this reason. It is really difficult in a piece of legislation to say, here's how we protect all easement holders from abuse, because every easement is generally got some variation in it. We lawyers like to use forms, so there's very similar language, but the scope and breadth of each easement in the state of Wyoming, and there's thousands, varies. And so it's very difficult, Senator, for example, to say, here's what overburdening an easement for a collector system looks like. Because in one case, it could very well be overburdening. In another case, it may not. It may be perfectly permissible based on the plain language of an easement. There's, for example, nothing that stops a landowner from saying, I grant you a 150-foot wide right-of-way, and you can construct transmission lines that run to a wind or a solar project that are 10,000 feet tall, whatever voltage, right? Someone could agree to that. You may question the logic and the reasonability of why they would do that, but they could agree to that. Another landowner might execute an easement that says your tower height can only be 150 feet. The easement is 75 feet in width. You get an additional 50 feet for construction. So it's very difficult to put in here a protection that acts as a true backstop. And what I think would happen in an attempt to do that is you would have situations, because the easements vary, where someone who has an easement goes, well, wait a second. What I'm doing is perfectly permissible. The landowner and I both agree, but now suddenly the law says I can't do that. And so that it almost becomes a game of whack-a-mole where you'd need to list out hundreds of or thousands of potential scenarios where an overburdening easement exists. And I would suggest that's what the court system is for, where on a case-by-case basis, a judge can figure out, did this particular use of an easement overburden? Did it not overburden? And one last thing I'll say, Senator Kolb, is to the extent it's a concern about new company comes in and starts doing different things, there's additional protections in the form of assignment law or the law in which that new company acquires the rights to that existing easement. So I would suggest layers of protection, and I get it. It's imperfect, right? I'm a litigator. I understand it doesn't always work out as the drafters had intended, but that's ultimately why we have the court system. But in terms of language to suggest, again, I think it's tough, but what I would suggest, if you wanted to keep something like this in, you would have to use language where it was made clear, and I frankly need some time to think about this, where it was made clear that this would only apply to scenarios where infrastructure already exists and you are expanding the scope of that infrastructure. But again, because the nature and amount of infrastructure depends on the language of the easement, I think that language is going to be difficult.
Senator Ide.
Thank you, Mr. Chairman. Just a couple of quick questions. The first one is, I always understood that the U.S. Constitution only allowed eminent domain eminent domain condemnation to the government. Second question is, if there's never been any issue with condemnation, then why does this stuff even matter? Those are my two questions. Thank you.
Mr. Pope.
Mr. Chairman, Senator Ide, as to the Constitution question, the Wyoming Constitution actually grants the right of eminent domain to a wide variety of folks, the government included. And Mr. Sutphin, who's going to testify at some point today, will talk a little more about the history of that. But essentially in Wyoming, it started as a way for folks to get access to water in the early days. So it was actually very much geared toward landowners. The Eminent Domain Act has expanded and codified, and it explains who can condemn under what circumstances. It provides the elements that a company has to prove. It requires good faith negotiation prior to ever filing a complaint. As to the question of why does it matter if no one has ever used it, that's the central question that I think I started with, that it is a solution that's in search of a problem. Wyoming does not have a problem where companies are condemning to get collector systems in place. The real net effect of this legislation is to remove a tool from the toolbox of a company that operates in Wyoming. And let me give you an example outside of the context of what this bill is that I hopefully help illustrates this. Wyoming gets, as y'all know, an enormous amount of revenue from the oil and gas sector. The oil and gas sector isn't necessarily popular with every landowner in the Powder River Basin. We represented an oil and gas company that was in the midst of a major development in the Powder River Basin. There was one landowner who already had this company's infrastructure on his property, but he decided that he didn't want a road and a pipeline that were necessary for a massive expansion of this play to go through his land. The company we represented offered that individual 3 times the fair market value of his entire ranch to purchase an easement that was a couple of miles. He said no. His counteroffer, and by the way, this is all a matter of public record in the condemnation case, his counteroffer was $1 billion. To put that in context, at the time he made that counteroffer, that was 1/4 of the GDP of the state of Wyoming. Unreasonable, I think, to say the least. So that oil and gas company was left with no recourse but to condemn that segment of land and justly compensate that particular landowner. Otherwise, a huge swath of that development would have vanished. And with it, tens of millions, potentially hundreds of millions of dollars to the state of Wyoming. That is the scenario for why condemnation exists. It's not because it is rampantly used. And I can tell you that particular client, it was the last of last resorts. They spent years attempting to negotiate with that landowner before they ever said, please file this lawsuit. That's the scenario that we want to have a tool in the toolbox to deal with, where there's a major project. It's going to be in the best interests of the folks that are involved. There's dozens or even several large landowners that really want it, and someone just says no and digs in their heels and shuts down that economic activity. That's why condemnation exists, is to say, okay, we'll go through you. We've tried, but we'll go through you.
At this time, I think I see Representative Davis has his hand up, but I actually think we're going to move to Miss Bud Fallon because she has another engagement this morning and is going to have to be leaving us. And I want to get her testimony, and we can come back to Mr. Pope and Mr. Sutphin after that. So if we could get Miss Bud Fallon pulled up, that would be great.
Thank you, Mr. Chair. So anytime you want to recall me, let me know.
Thank you. Miss Bud Fallon, at any point you're ready, go for it.
Let me check my computer knowledge. So can you hear me?
We can. Yes, ma'am.
All right. Well, thank you very much. And I apologize for having to jump in the middle of another witness. At 10 o'clock, I have to leave. One of my FFA teams that I coach, actually, who appeared in front of your committee earlier this year for a practice, won the state competition. And I've got to go catch an airplane to Indianapolis to see how they do in the national competition this week. So I really appreciate this. I think what I want to do is start with a story that is happening to me right now. And then I want to talk about the bills and some of the testimony that has already been given. So my story is that my office, Frank Fallon and Connor Nicholas, are representing a group of landowners dealing with the Black Hills transmission line. The Black Hills transmission line is a high voltage KV transmission line, the kind with the big silver towers, that's going 260 miles from Cheyenne, around by Douglas, and then over to Scottsbluff, Nebraska. The landowners are in Laramie County, Goshen County, Converse County, and Platte County. And our law firm represents about 100 miles of landowners on that line out of the 260 miles. So interestingly, I bought some property near Dwyer Junction this last year so that Frank and I would have a better place to put our calves in the spring, because it's just too dang windy and cold here in Cheyenne. And so I joined the group because the Black Hills line is going to cross the property. I have to tell you, Black Hills was not excited about dealing with the landowner group. They went to the Public Service Commission without telling any of the landowners about the project or what they were doing. And only because Frank and Connor got wind of Black Hills being at the PSC about a week before it happened did they gather up a whole bunch of landowners and storm the PSC and got the PSC to let us intervene in the Black Hills case. And then they said that they would grant Black Hills a certificate of convenience and necessity if Black Hills tried to negotiate with the landowners to come up with an easement. So Frank and Connor have been working away on coming up with an easement. There's been lots of meetings and discussions. This has only been going on probably for, I don't know, a little less than a year. Connor and Frank finally got to an agreement with Black Hills on the issue of the compensation, but the parties were still working through trying to deal with liability and reclamation. And so even though Black Hills keep saying, oh, we're working in good faith, and they keep sending draft back and forth, 2 weeks ago, I got a notice of condemnation from Black Hills. They sent me a 65-day notice. It said, you either sign this easement as a landowner, and they sent it to both landowners in the group as well as out of the group along the 260 miles. And we got a letter that said, you sign this easement, or in 65 days, we're going to start condemnation against you. My office has fielded hundreds of phone calls from landowners in an absolute panic over this letter. The easement that Black Hills sent with the letter was about half the compensation that they'd agreed to with our attorneys. And the reason they said that is because if the attorneys were going to insist that Black Hills have the liability if something goes wrong, then they couldn't pay the compensation we'd requested. And when you're talking about these transmission lines, liability is really a big issue. I understand the company is always going to claim that if a line breaks or a tower goes down or a fire starts, they are always going to claim it's an act of God because of high wind, because, you know, lightning strikes the tower. The problem for the landowner is, though, is that the fire wouldn't have started if the line across their property didn't exist. But Black Hills seems to think, and every other company we've ever dealt with seems to think, that all of that liability ought to be on the landowner. Black Hills also got lots of attorneys. It's a big company. I want the legislators in the room to please think about your individual ranchers in your counties. How many of them have landowners on or have attorneys on staff? And so if a line breaks and a fire is started and it burns up somebody's ranch, the first thing that's going to happen is the company is going to say, oh, it was an act of God. You've got to deal with it yourself. And even if we can prove negligence on behalf of a company, it's up to us to hire the attorney and the experts. And I got to tell you, there's not all that many of your ranchers that you represent that can afford that. So even though Black Hills is claiming, oh, gee, we're still negotiating with your attorneys, I can tell you that that 65-day letter, that threat of condemnation, does not feel like good faith. And there are landowners now who are signing this easement because they don't think they have any other choice. There's been testimony at this committee and then in front of the committee, the last committee I was at, where the companies keep saying, oh, but we don't ever have to go through the condemnation. We don't ever actually condemn these guys. But it's the threat. Because the landowner can't say no. We can't hang in there on what we need for compensation. We can't hang in there and argue about what we want in terms of liability protection. We can't hang in there and argue about what we need for reclamation once the easement is built. And so I very strongly encourage you to continue working on these bills. And the truth is, if I can feel pressure as an attorney who understands all this condemnation stuff, getting that letter, how are other landowners going to feel that don't know the process and aren't involved in the process? And I know that's Black Hills and everybody's going to say, oh, it's different, it's different. But I think that that is a perfect example today that's happening when you're granting such broad condemnation authority to these companies. Now, with that little introduction and story, let me talk about the two bills that are before you and offer some ideas. So the first bill that I looked at is the one that you guys have labeled as 24 LSO 123. And that's the bill that talks about how these collector lines and these smaller lines are going to have to go through the hearing process in front of the PSC before they have the power of condemnation. And I think that was based on the discussion at the last hearing I attended, where we were talking about companies can just exercise the power of condemnation without going through some sort of a hearing. So I think the thought of forcing them through the PSC is good. My concern with having the hearing at the PSC level is that A, the PSC is in Cheyenne. These companies appear in front of the PSC all the time with their experts and their attorneys. And landowners that don't understand the process and are just simply trying to take care of their cattle or raise their crops are honestly not going to have the time or the money to come to Cheyenne and participate in the very complicated PSC process. So what I would suggest, and as maybe a thought, is that you also set it up, or that you allow in your bill that county commissions have the ability to hear these cases and then make a recommendation to the PSC. Now, the counties that didn't want to participate, that I'm not trying to make counties do anything they don't want to do. So if you're a county and you say, look, we don't have the manpower, we don't have the time, we don't have, the whatever to be able to participate or to be able to offer a hearing so that we make a recommendation to the PSC, that's fine. I'm not suggesting that counties have to do it. But county commissions that want to have a hearing in the local area for the landowners so that the landowners can make their points, and then the county commission can suggest that to the PSC. That just seems like an easier way to accommodate the concerns of the landowners, and quite frankly, to force these companies to come to the turf of the landowner instead of always forcing the landowner to come to the turf of the PSC where the companies are at all the time. So that would be my suggestion on 24 LSO 123. Now, with regard to House Bill 24 LSO 113, I have some additional thoughts. I did like the 85% threshold. I can't tell you that 85% is the right number or the wrong number, and I'm not sure where that came from. But I do like having that threshold because it forces these companies to do true negotiation with willing landowners, but it doesn't hold the company hostage if you have the one cranky, unreasonable guy that just says no to everything. And so I do like that threshold. It also stops them from doing like what Black Hills is doing to me and sending notices of condemnation to every single person along the line, which is huge bargaining leveler on their behalf and leaves the landowners with nothing. I would suggest, though, that the committee also look at minimum easement standards. As I said, one of the big issues that we're fighting with Black Hills over is the liability on the private land. Private landowners are normally not asking for transmission lines across their property. And if a line breaks and a fire starts, which we absolutely know does happen, in my opinion, the company is in a much better financial place to deal with it than the landowner. The company is making money by allowing power to go through that line every day. The landowner is not. The landowner gets his payment. And so I would really look at this liability issue and make sure that the liability is more evenly distributed than a big company over a small landowner. All right, with regard to the compensation that you have in Bill 113, I would look at the Barlow versus Green Court case. That was a Wyoming Supreme Court case in 2013. The citation for your attorney is 301 Pacific 3rd 75. And I would just make sure that the language in your bill fairly considers what the court said in the Barlow versus Green Court case. What that case said is that in addition to considering fair market value, that when compensation for condemnation was set, it also had to consider what other pipeline companies paid for an easement in that local area. So it's not just for that one single line that crosses several property owners. If you're dealing with a new company, but you've got 3 existing pipelines all within the same area, the value for those easements should also be considered. And so I just want to make sure that the Supreme Court handed that win to Wyoming landowners, and I would not want your compensation language to take away what the Supreme Court granted to us. If I could go back to liability again, I think another thing I would look at is that there needs to be limits on the landowner liability to the extent that he can insure his property. One of the issues we hear from companies all the time is that, well, if your employee goes out and accidentally plows up a line or digs up something or hits a tower, then you need to be able to compensate the company, the multi-million-dollar company, for damage. The problem for landowners is I can't get property or liability insurance to that value. And so while I agree that the landowner shouldn't be held harmless because it was your employee or whatever you did caused the problem, the ability to pay for the problem can force a landowner to lose his whole ranch. Whereas the company is in a much better place to deal with that. And so I suggest that we look at liability insurance and have the value owed to the company based on the limit of some kind of a liability policy. Another thing with regard to minimum easement standards needs to be abandonment. There's some of these easements, some of these facilities, whether it's wind towers, whether it's collector lines, whether it's pipelines, there is a useful life at the end of these. If the property is condemned for these uses, the eminent domain statutes do not deal with what happens at the end of a project's life, or what happens if the company goes belly up and just leaves that stuff on your property. It's the landowner who then gets to pay to either have it removed or cleaned up. And I think without some way, some requirement for abandonment so that the company, if they go belly up or they just get tired of doing the project, they've got to take care of their structures on the landowner's land and not just leave some landowner to have to deal with the mess. I would also look, if possible, at minimum reclamation standards. If you have somebody coming in and putting in a pipeline or a transmission line, there's nowhere in the eminent domain statutes that say what the minimum reclamation has to be to try to get the landowner's land in as good a position as he can. And the companies are going to argue, oh, if you make us do all these things, we're going to move out of the state of Wyoming. Oh, if you make us do all these things, that hurts our bottom line. But on the flip side, it hurts the landowner's bottom line to have a pipeline or collector line go through that is just a big weed patch in the middle of his field. And I think because Wyoming is an agricultural state, that we ought to be also looking at the bottom line for the agriculture industry. Now, I'm sure that some are going to say, oh my gosh, Karen is totally against energy development. And that is absolutely not the case. I do have landowners that I represent that have fairly negotiated deals with companies and are very happy to have the property or to have the company deal with the land. I'm absolutely fair. The issues I'm talking about are the issues when eminent domain is used or threatened, and the landowner feels like he's got no choice but to sign an easement. And while you can't find very many cases on that, I guarantee you in Wyoming that that is happening, and that's right now happening on the Black Hills line. You were talking about the language in the bill about not using an easement for more than one project. And although I mean, as an attorney, and I get wound up in difficult language reading too, I'm wondering if maybe you could fix it with some sort of a grandfather clause. I actually disagree with the proposition that you should just strike the language that says you can't build another project in the same easement. I understand that landowners can go hire attorneys and that they can take this all to court, but I'm wondering how many can actually afford that. And so I think the language ought to be in there, and to address the concerns of the companies, maybe what you can do is grandfather in the language of existing easements and apply this prospectively. I could probably think about it more and come up with additional suggestions. I think I'm going to quit now. I've got about 10 minutes before I've got to go catch an airplane in Denver. I appreciate the opportunity to testify in front of you and the opportunity to do it by Zoom. And I will let you all know how my ag kids did, especially since you guys heard them last fall at your ag committee meeting. Thank you.
Thank you, Karen. I know Representative Davis had a question. He had his hand up a bit ago, so I'm gonna call on him first, and then the rest of you get your questions ready for Ms. Bud Fallon.
Thank you, Mr. Chairman. Unfortunately, Karen stole my light there. How many of us small landowners can afford a good attorney to fight these big companies? So I think she hit it right on the nail there.
Did I just hear you say there are some good attorneys, Representative Davis?
Sir, Mr. Chairman, yes, there are some good attorneys out there.
Okay, just clearing that up for the record. All right, is there any other questions for Ms. Bud Fallon from the committee? So Karen, I wanted to follow up a little bit on the last bit. You were talking about the paragraph, which it's in both of the bills, that exact language regarding existing easements. And so I just wanted to follow up a little bit on that language, because I also see I understand the testimony of Mr. Pope earlier, and really we could get into some constitutional issues there, ex post facto, et cetera, on interfering with existing contract. And I think that's what he's talking about. The committee has objectives that are different. That I don't think that's what we're trying to get into. But do you have any ideas on specific language that would be helpful there? I know you talked about a grandfather grandfather type language. I'm just not sure how that exactly would work, because also on even on a new easement, for example, the landowner can contract for whatever they want. That's up to them to contract. If they want to give a holistic, huge, authorization in their easement, they can do that. And maybe they're getting compensated for that. Maybe they're not, I don't know. But from your perspective, and I know you deal with this more than most, is there anything you would have in mind on how we could address that problem?
Mr. Chairman, thank you for the question. Perhaps then maybe what we need to do, or what you should do, is to add language that says something like, unless specified in an existing easement, and then continue with your language. Because I do agree that that I'm really supporting the landowners here, and if they have contracted for that, then that is their right, and they need to live with the bargain that they made.
Thank you. That's helpful. Senator Cole.
Yeah, thank you, Mr. Chairman. I had a question in a general way about the liability that you'd face with having a right of way on the property that you've apparently agreed to having a right of way, or maybe it's just got condemned and you have a right of way on the property. Is there some, I'll use the word scheme, any policy that would in fact cover you by the utilities using that right of way and putting up towers, and then through an accident, let's say, not through malice, the towers were damaged? What would you think about some language that would basically have to have the utilities bake that into their right of way agreement? But with that, and also, you'd be excluded if there was deliberate actions taken against those towers and it was damaged, then I don't see how the landowner would escape that liability. What were your thoughts on that, on trying to deal with the potential of, frankly, going out of business as a rancher over an accident with a right of way, say, that were involved with electrical towers? We'll just use that as an example. Thank you, Mr. Chairman.
Ms. Budfallon.
Yes, Mr. Chairman, we actually deal with that in the easements that we are able to fairly negotiate, and I would be happy to send you that language. We usually talk about how, if it is an accident, that the limit of the landowner's liability is based on the insurance policy for that property. And then we've done some research that generally in Wyoming, and I don't have that figure in front of me, but generally your policy, we know what the policy limits are for landowners. And so we try to cap accidents at that insurance language, so that the landowner does deal with the accident, but it's not where you're now going to pay the cost of disrupting service for 50,000 people based on the electric line or whatever the fact scenario is. And I'm happy to send you that language.
Any more questions for Ms. Budfallon? All right, thanks for being with us today. Tell the team good luck, and please send us an email and let us know how they do.
I will do that. Thank you very much.
All right, so we'll move back to the room, and Mr. Pope, if you want to come back up and see if there's any more follow-up questions for you. And then whoever's next, if they want to get queued up, we'll keep moving along here for a bit.
Mr. Chair, before questions, could I give some thoughts on a couple of things Ms. Budfallon raised?
That would be fantastic. And actually, if you could really, and at some point hone in on the suggestion she made on the language regarding the existing easement, because I think that would be helpful to guide all of us as well.
Sure. And Mr. Chairman, thank you. Why don't I just start there? So this won't come as a surprise. I don't think that grandfathering, as the chair mentioned, helps get at the issue either. Grandfathering would in effect say any easement before the date of the act, that's fine, but any easement after is now subject to that language. But that same issue of what does the individual easement say remains. And likewise, language that Ms. Budd-Fallon suggested about unless the easement otherwise says the statute applies, you have the same problem. And in a big picture sense, what's going on is it's an attempt legislatively to manage the risk and the relationship between individual companies and landowners across the entire state of Wyoming. I don't think that's a task that is really doable with any language. Like I said, I think the way you'd have to do that is give a laundry list of examples. And the question I would ask is that really the business the legislature wants to be in? We believe that our landowners, and trust me, I've negotiated with them, they are smart, they are savvy. And I get it. Sometimes leverage and bargaining power differs. Some companies have more, but I will also tell you the situation gets reversed where the landowner has a tremendous amount of leverage. I'll give you a great example. Oil and gas company was in a time crunch to get access to land to build a pipeline. They had a separate contract with a midstream company where they had to have a certain in-service date for their pipeline system. As a result, that particular landowner had a tremendous amount of leverage and got a really, really good price. So leverage does work both ways. But because each of those individual easement situations, collector system or otherwise, are going to vary, I think it's going to be very difficult for this committee or the legislature writ large to develop language where you don't encounter the scenario of, wait a second, my easement says I can build X, Y, or Z. Now this legislation seems to suggest I can't. That's the scenario you get into where the legislature has taken a property right and litigation ensues. And I just don't think there's a way to write yourself out of that. I think at the end of the day, and this, depending upon the audience, this could be great or not, you have to trust the court system as an opportunity for a landowner to go in and say, my easement does not permit whatever it is the company is doing. I need relief, and trust the court system will provide that. That's why we have that. And the benefit of doing it that way is the court can take those easements on an individual basis, can look at the specific language that the landowner and whoever else the landowner contracted with agreed to. And the court can say, yes, that's permitted. No, that's not permitted. I would suggest that's the best way to handle it. Because again, I get trying to find a solution where this language becomes workable, but essentially what you're trying to do is create protections for thousands of contracts that all contain different language. Let me, as part of that, move to a couple of things Ms. Budd-Fallon said about minimum easement standards while we're on that subject. First, on the reclamation side of things, the Eminent Domain Act already provides reclamation requirements. That's 126.714. In addition, what typically happens in a condemnation case, and this is actually required by statute, as part of the good faith negotiation process that must happen by statute before you initiate a court case, you have to send an easement, a surface use agreement, whatever contract you are trying to negotiate to the landowner. And that contract must provide for reclamation. That's by statute in 126.510 and 509. So that is all part of that overall process. Abandonment can also be part of that. Critically, the Eminent Domain Act expressly provides that even in the course of good faith negotiations, you can negotiate for whatever protections you want, whatever type of contract you want. So there's no boundaries or limitations on what the landowner can request or what a company can request. It's truly just, we need you to negotiate. So I don't think there is necessarily a need for some of those minimum easement standards. I think the law has already provided for those. But again, it gets you into that same pool about this overburdening easement language we've been talking about, which is that's a relationship and a set of risk that does the legislature want to manage that on a contract by contract basis? Or do we want to trust the folks in Wyoming to manage that? Albeit understanding that every negotiation situation is different. The leverage is different. The knowledge and expertise each side brings to the table is different. But that's why we have contracts. That's why people like me exist, to provide advice to folks. And I will tell you, one of the reasons my practice exists is there are law firms in the state dedicated exclusively to representing landowners. And they are home to some very, very good attorneys who make my life and my clients' lives difficult on a regular basis, but it's because they're good at their job. The last thing I wanted to mention before I took any more questions that the committee may have is the concern Ms. Bud-Phelan raised about Black Hills and public utilities. That would largely not be changed by this legislation. They would still be permitted to condemn. The folks that I'm here representing, the American Clean Power Association, are largely the companies that are not public utilities. They are private developers who develop projects, and in some instances they build and they operate those projects, and in other instances they sell them to public utilities or to other private developers who build and operate those particular projects. So I can't speak on what's going on with Black Hills, what they're doing. I don't represent Black Hills, never have. But the concerns that the folks I'm representing here today, they are not the folks who are out there just sending a sort of canvassed list of initial and final offer letters to landowners. Thank you.
Madam Co-Chairman.
Thank you, Mr. Chairman. Sir, I was just reading over the statute you cited, and that is only in the case of condemnation. Am I reading that incorrectly? Because we're talking about minimum easement standards. This is just the statute you referenced is just in the instance of condemnation. And so you've stated before that we were not using condemnation, that there's been none of that happening. So then what are the minimum standards for an actual easement? As you know, the legislature provides minimum standards for a variety of different things in statutes. So what are the minimum standards for reclamation and abandonment now if the property is not condemned?
Mr. Pope.
Mr. Chair, Senator Steinmetz, it's going to vary. You are correct. 126.714 only applies in an instance where you've condemned. But for projects that don't condemn, that build, it's largely governed by the permitting requirements. So for example, the Industrial Siting Act, as part of that application process, you are required to provide a reclamation and decommissioning plan that's enforceable by the state of Wyoming. You also have to provide a reclamation bond that is set by the Industrial Siting Division, which is based off of the projected decommissioning and reclamation cost of a particular project. It varies based on the size and complexity of the project, but the Industrial Siting Division regulations do set, for example, thresholds for how deep, when you pull a wind turbine tower or the footers of a solar collector system or a transmission line, the pad, how deep do you have to pull out the infrastructure? Where do you put the cement? That's all in those regulations. And importantly, the decommissioning and reclamation plan is subject to the evaluation of the Industrial Siting Council. And so they could say, we don't like this plan. We think you need to change it. Landowners are also permitted as part of the industrial siting process to object and come to the hearing before the Industrial Siting Council and raise any concern, reclamation or otherwise. The other layer, when it, particularly for wind and solar, not necessarily for a standalone transmission line, but and sometimes for standalone transmission lines, there's a county permitting process. Could be a conditional use permit, could be what we call a WECS, WECS permit, which is Wind Energy Collector System permit. That in particular is required by state statute for wind and solar companies. And so as part of that county process, there are also county regulations that deal with reclamation standards. And likewise, you can have a landowner who has signed an easement, a surface use agreement, whatever land control document that provides for those reclamation standards. So I would say in a typical renewable development project, there's kind of 3 different layers of reclamation protection outside of condemnation.
Representative Alaman.
Thank you, Mr. Chairman. Sir, Ms. Fallon stated that they have not been condemned on. All they have received is a very nasty letter saying that if you don't follow me, you're going to be. Has the American Power Association or any of its attorneys sent out the same letter, or not the same letter, but a letter saying we are going to condemn if you don't fall in line? Has that happened?
Mr. Pope.
Mr. Chair, Representative Alaman. So the American Clean Power Association would not have. It is just the trade organization that kind of is the umbrella, but the individual companies within it, I am not aware of any that have sent what we would call an initial offer letter. The way the statute works is at least 90 days before you initiate a condemnation action, you have to send an initial offer letter that meets the requirements of the statute and begins what we call a 90-day good faith negotiation window. There's a second letter, a final offer letter that comes later in that process. But none of the companies that I have represented, none of the projects that I have taken through the industrial siting process have ever threatened condemnation via an initial offer letter.
Thank you.
Senator Cole.
Yeah, thank you, Mr. Chairman. Mr. Pope, Counselor, I have a question of what you talked about a little earlier, and I just wanted to give you a chance for clarification. It almost sounded to me like if there was a statutory change, somehow it would be retroactive that would affect past contracts. Now, could you clarify that? Because I'm confused from my little knowledge I do have. Could you, I guess, explain your point of view, what you meant by that statement?
Mr. Pope.
Mr. Chair, Senator Kolb, absolutely. So the way, and I'm looking at 24 LSO-0123, the way this language looks, it's not as if it is a retroactive, we're going to go back and every single easement is now subject to that. I think section 2 on page 3 says it applies to eminent domain actions initiated on or after the effective date of this act. But what gets unclear, at least to me, is the red line language on lines 1 through 4 isn't necessarily tied to a condemnation action. It's just tied to existing easements. But I think at the end of the day, whether it's retroactive or not, you're going to have easements that are signed after the effective date that with this language arguably are useless because you couldn't build a collector system and that right has been taken. Likewise, even if you have an easement that predates this act, collector system is on it. 10 years later, company says we need to build a new collector system. This language would prohibit that. But if the easement itself permitted 1 collector system, 2, 3, an infinite number, for example, that is a property right that this legislation has now taken away that was negotiated between that landowner and that company.
Follow up.
Yeah, thank you, Mr. Chairman. We can't go back in time legislatively. We can't make retroactive law, right? Is that correct?
Mr. Pope.
Mr. Chairman, Senator Kolb, you can make retroactive statutes. But I think the chairman was getting at is that in some instances, retroactive statutes run afoul of other laws, other constitutional provisions. But you can do it.
Any more questions for Mr. Pope? There's Representative Davis. I saw you this time.
Thank you, Mr. Chairman. Not being totally familiar with the easements that Mr. Pope is considering here, I think the reclamation is a huge issue that needs to be weighed in and very specifically addressed, because I know as a landowner, the tools are very limited to the landowner to force these companies to come in and follow the easement. Other than the legal side, that's the only tool that we have if the leasee is not following the contract, and which becomes very expensive as a landowner. I mean, we, as far as a contract for weed control and reclamation are concerned, those are sometimes overlooked and shuffled aside. And so I think that needs to be addressed in this somehow, that we as the landowners have a tool or an avenue that we can follow to actually apply pressure to these companies.
Don't you think, Mr. Pope?
Mr. Chair, Representative Davis, look, I agree. I can't disagree with the statement that no landowner wants to just have abandoned infrastructure left on their property without any recourse. But as I discussed with Senator Steinmetz, I think that protection exists through the industrial siting and county permitting processes. Representative Davis, you mentioned weed control, for example. I'll direct y'all to the Converse County regulations, which I've looked over recently for a project. There are specific weed control requirements contained in those. Likewise, the industrial siting regulations also require contact between the project company and the local weed and pest control districts in and around where the project will be sited. And I think at the end of the day, the debate we're having is whether or not those protections are sufficient and whether or not there's an enforcement mechanism by the landowner. I think outside of the context of condemnation, the reclamation bond that is required to be posted, and by the way, required to be updated on I think it's a 5-year basis. I'll double check that. But it gets updated so that, for example, a project that said it'll cost 10 million, but at the end of the day, it costs 50 million. There's not a $40 million delta there. That's the best protection for the landowner, because that is something that the state has immediately at its disposal and has statutory enforcement authority to take that bond and go do the reclamation work, even if that company goes belly up, even if that company just says, we're done with the state of Wyoming and our project and we're not going to follow that. The state can grab that money and get the job done.
So one last question, then I think we'll move on to a new witness, but I just want to make sure that the record's clear that, and it's your testimony that the industrial siting reclamation bond would apply to the collector systems themselves. Is that correct?
Mr. Chair, generally speaking, yes. And I'm going to give you the caveat because I'm a lawyer and there always has to be a caveat. If a project that goes through the industrial siting process permits both we'll take a wind farm, the turbines themselves, the roads themselves, and the collector system that runs to a substation controlled by a public utility. If that's all within the package of the project that's getting permitted, then absolutely, those reclamation standards, the required reclamation and decommissioning plan, the bond, all of that applies. There are rare scenarios where a third-party company comes in and is going to build a longer distance transmission line to a substation. And I'll give you an example of that. There is a wind farm in Carbon County. It was permitted. A different company, because the transmission line to the substation is, I think it was a total of about 60 or 70 miles. That third party was going to build and operate, is going to build and operate that particular transmission line, which functions as a collector system for that particular wind project. That transmission line is not subject to the industrial siding process, but it is subject to the conditional use permitting process in Carbon County, and in this particular instance, Albany County. So the Carbon County process, and I represented this particular transmission line, that permitting process placed reclamation requirements on that. Now, there's no bond associated with that, but because it's a standalone transmission project, the actual reclamation dollar amount is substantially lower than a wind farm or a solar facility. But I would say that, Mr. Chairman, that scenario is very much an outlier. The vast majority of at least renewables projects that have gone through the industrial siding process have packaged the generation facility and the collector system altogether.
All right, thank you. I think we'll move on to our next witness. Whoever wants to testify, please come forward.
Thank you,
Identify
Mr.
yourself.
Chairman.
Yep, thank you for your testimony, Mr. Pope.
Mr. Chairman, Committee, Brett Moline, Wyoming Farm Bureau Federation. I'm hearing a couple of different things this morning. One of them is an interim topic to deal with reclamation and liability in reclamation. You know, are we covered? Are we not as landowners? I think that's a question that needs to be answered, but dealing with the issue at hand, the two bills dealing with eminent domain, it's been stated several times, well, it's not used. Well, that's not, it is used. One of my members in, I believe it was either, my information is either 2017 or 18. They tried to negotiate with the power company. This was dealing with power lines for a wind project. They tried to negotiate. The company that operates in several Western states didn't negotiate. They were condemned. So it is used, probably rarely, but it is used. And I think that brings, you know, the issue to home that we need to do something. And of the two bills in front of us, my organization would prefer the draft 123 over 113. Just makes it black and white. You can't do it unless you're a public utility. Now, what would that do? Would that stop wind projects? No. This doesn't deal with the generation. This deals with the collector lines. So if you want generation, you can have it. They can't condemn a tower or solar facilities on your place, not to my knowledge. But if you want it, you can build those. What we're dealing with is the collector lines. And those are the problem. The people that don't want the power, don't want the projects, don't have to have them, but they can be stuck with the collector lines. And I think that's the problem that we're dealing with today. And again, would prefer 123 over 113. A little bit on some of the contracts, a little bit of experience my family's had with them. It was dealing with a different type of project, but it was a pipeline. But most of the landowners are becoming more sophisticated. They are single use. You can only do this project. If you want to do another project, you have to have a separate easement. You know, that is probably more common, but you know, the liability issues, what the landowner group in northeastern Wyoming was told, well, yeah, we'll take the liability, but that means we're going to pay you a lot less for the easement because we have added costs. And I think we need to outline that in state law, again, perhaps as an interim topic to define what liability should go with the landowner, what should go with the company. But again, probably an interim topic. You know, they're talking about, you know, the thumbs on the scale. Well, if they don't have this as a thumb on the scale against the power companies, the current situation with the use of eminent domain is one heck of a thumb on the scale against the landowner. You can say no, you can mean it, but it doesn't work because they have the power of eminent domain. And that is a heavy thumb on the scale. With that, Mr. Chairman, you know, another comment is that, you know, I'm from the government and I'm here to help you. You should be. That is a role of government at the county level, the city level, the state level, and the federal level. A role of government is to help protect private property rights. And that's what this bills would do. I think we need more of it. I think with that, Mr. Chairman, I'll quit babbling and I would take any questions you or the committee may have.
Thank you, Mr. Moline. Any questions from the committee? Senator Ide.
Thank you, Mr. Chairman. Just a quick question. I lost you there a little bit. So you're in favor of 113 or 123 versus 113, or both of them, or just one over the other? Could you kind of elaborate on that? Thank you.
Mr. Moline.
Mr. Chairman, Senator, support both bills. If I had to take a choice, I would prefer Bill 123, but 113 has some positive aspects that would help out my members and other landowners. Mr. Chairman, I hope I answered the question.
Any more questions? All right, thank you,
Thank
Mr.
you.
Moline. Next witness.
I hope, Mr. Chairman, because I'm a witness, I don't have to be sworn in before I give my testimony.
No, sir, please proceed.
Thank you, Mr. Chairman. Jim McGaggan with the Wyoming Stockgrowers Association. And as you will recall, a draft bill from about 12 years ago that I brought to you at your last meeting is actually the basis for 113 in this case. And the way we've looked at this issue is really in terms of how we balance the rights of a variety of landowners. I mean, whether or not we like or dislike wind energy is not the subject before us. I know numerous landowners in this state who have benefited very significantly from having wind energy facilities constructed on their land, and it's kept branches in family ownership. It's enabled them to make improvements, etc. We have to balance that against the rights of neighboring landowners. And if you can't have a collector line to remove that wind energy, you don't have the wind power. So we're balancing that. And then the third party in there is the one who wasn't able to negotiate an agreement. So as we look at all three of those, we feel that 24 LSO 1113 achieves that balance. It doesn't allow a party who's being paid handsomely to have wind energy on there to dictate that everybody else then is going to be condemned if they don't agree to have a collector line. And yet at the same time, it assures that if a company negotiates wind energy lease and they then successfully negotiate collector line leases with a wide array of landowners representing the 85%, and I'll address that in a moment, and as well as 85% of the land, that one disagreeable landowner can't prevent all of those other landowners from garnering benefits that they have voluntarily agreed to, none of them under pressure. I certainly agree that while eminent domain isn't widely used as a tool that ends up in the courtroom, it is a factor in every negotiation if you know that if I don't agree to this, I'm subject to eminent domain. But I think it strengthens the position of the landowner if you know that unless I and the total of 85% of my neighbors representing 85% of the land agree to this, we're not subject to eminent domain. So I think it creates that balance that we feel is important, of saying the majority have to agree, and yet one person can't keep a whole array of landowners from deriving benefits to which they're entitled. As far as the 85%, that was in the draft that I had brought to you earlier. That was developed after quite a lot of discussion back in 2011 and 12 as to what is an equitable amount. I mean, could it be a little higher, could it be a little lower perhaps, but the feeling then was that if they were able to voluntarily negotiate 85%, that means that the wind energy company has generally offered terms that most landowners have deemed favorable and met a standard in order to be able to then, if necessary, use the condemnation against the remaining 15%. But the terms that the 85% get because those have to be negotiated without any threat of condemnation, are, in our view, going to be more favorable than they would have been if that threat had been hanging over it. And that makes it less likely that there are going to be landowners left over who can't get terms that are favorable to them, unless it happens to be a landowner who just says, I don't want the collector line across my property. Doesn't matter how much they offer me. So it's trying to seek that balance, and we feel that this does that. With regards to the minimum easement standards, whether it's abandonment, liability, reclamation, et cetera, apart from what are covered in other statutes, in order to move this forward and not make it overly complex at this point, one thought that I would share with the committee is on page 4 in subsection C, we require that the compensation be the equivalent of the average given to other owners of the land. Might it be possible to consider adding another provision in there, another subsection in there that says that the terms and conditions of the easement in a condemnation shall not be less than the perhaps the average of the terms and conditions offered to all the other landowners in the voluntary negotiations, as a way to provide some amount of protection without getting into, at this point, the details of defining what constitutes, what's the extent of liability, what's the requirement for reclamation, allowing those things to be negotiated by the parties who negotiated voluntarily, but then providing a provision that for the party or parties that are subject to the condemnation, that they can't be condemned under any terms that are less favorable than the average of those others, just as a possible way to approach that. With that, Mr. Chairman, Wyoming Stockholders Association is very supportive of 1113. We're reluctant at this point to support 123 out of the fear that that's giving potentially a single landowner too much authority over what a wide array of cooperating landowners can garner to their benefit on their lands. I'd be happy, Mr. Chairman, to take any questions.
Thank you, Mr. McGagnon. So I want to just ask you the first question, which is, you heard lots of discussion back and forth. Ms. Bud Fallon, Mr. Pope, and several of us on the committee had questions regarding subparagraph E on the top of page 5, which is the existing easement language. What is Stock Growers' thoughts on that particular provision? I'm assuming that came from the original draft bill as well. And maybe just give us your thoughts on that. And then if you think there's any ways to address the concerns raised by some of the folks today.
Thank you, Mr. Chairman. And I had not paid a lot of attention to that because I was not reading it in the way that some of the parties here today have read it. But I can understand certainly what that concern might be. Just as they thought that we were to say commercial facility generating electricity shall not use an existing easement to place additional collectors, maybe whether we need to say place additional collector systems necessarily, but even broader than that, shall not use an existing easement for any activity beyond the specific terms under which the easement was granted, or something to that effect. That's fairly broad, but if the easement said we're going to do X amount, you can't come back and say, well, we're just going to run another line on that same pole or something. If the easement, whatever the easement said is what you're bound by, is what I'm thinking of as one way forward. Whether that covers all scenarios, I'm not certain.
Yeah, so just follow up on that. One of the things I'm struggling with in my mind, and I hadn't thought of this either until Mr. Pope brought it up, but it is true that you can't use an easement as beyond the terms of the easement anyways. And so I think his point is, well, why do we need that language in there? And that's what I'm struggling with too, is all of our suggestions, even the one Ms. Bud Fallon had, simply says you can't do what the easement doesn't allow. And so I'm struggling with what situation are we trying to cover there with that particular bit of language, because I don't understand. I see Representative Slagle down here has his hand up, and maybe because it's a big deal in his part of the world, maybe he can explain that or has some follow-up. So I'll maybe shift it down to him. But while he's talking, think about that, because that's what I'm struggling with, is what will the actual purpose of paragraph E be if we're saying, yeah, you can do what's allowed by the easement? That's what I'm trying to get at. So Representative Slagle.
Thank you, Mr. Chair. One comment I have is up in our part of the state, northeast part of the state, there's been a lot of oil activity, a lot of pipelines. And most of them were put in 50 or 60 years ago. They were just granted easement. There were no conditions. They just had the easement for the pipeline in. Now new companies have come in, bought the oil pipelines, taken over. There's no strict restrictions on what they do on those easements. And they've just done all kinds of stuff that where landowners aren't getting paid any damages. And the problem is they're small enough companies and small enough landowners. They don't have the money to hire a lawyer to come in and say, we need to do something with this. So they're just having to sit there and watch these oil companies come in and do all kinds of stuff on their property with no restrictions.
That's very helpful. Thank you, Representative Slagle. Do you have anything you want to add to that?
Mr. Chairman,
Mr.
I
Magagna?
would just add one other thought. I would concur with you that if you exceed the terms of your easement, obviously in litigation, the landowner is going to win in that litigation. I've been trying to think back to my involvement with this back in 2010 and 12 as to why that language was put in, and I have not been able to recall any particular reason why that was brought forward. So in one sense, I would be comfortable with that language just being removed from the bill. Certainly wouldn't change our support for the bill. On the other hand, some language that in there might just serve as both a reminder to the companies acquiring easements and a comfort to the landowners in these easements that in fact is the case. But so either way, with some clarification to it, I certainly recognize how the language as it's written can cause some confusion and would be in favor of either clarifying it or removing it.
Senator Cole.
Thank you, Mr. Chairman. Mr. Magagna, I'm back on the 85% quandary on just how that came about. And I am very concerned, as you know, I'm very concerned about having a number that's too high, and it poses a reverse imbalance to what we're trying to get a balance to. So I guess I'll ask you is where did that 85 come from, if you factually know? And then the second question I have is what would be wrong with posing a 2/3 majority as it is in the House and Senate for introduction of bills, which seems to be something that we all live by? But what would be wrong with a lower number? Because in the thought that, do you think it's in our best interest to push forward a really high number that could jeopardize the entire bill? I mean, what were your thoughts on that? Thank you, Mr. Chairman.
Mr. Magagna.
Mr. Chairman, Senator Cole, I certainly don't have any perspective as to whether the 85% jeopardizes the bill or not. I certainly understand the point you're making. My recollection is at that point in time, there was some, I won't say negotiation, but there was some good, strong discussion between some of us who were representing landowner interests and at least one law firm at that time that was representing some of the very nascent wind energy firms that were operating in the state at that time, as well as with members of the legislature. And the attempt was to find that magic number that is not so high that it could preclude projects from going forward, but is high enough that if you've reached 85%, you've negotiated in good, and it is 85% of the landowners and 85% of the land. So that means you've really engaged in good faith negotiation and convinced the vast majority that this is beneficial to have on my property and go forward. The concern I see with lowering that, and I'm not saying it wouldn't be justified perhaps, is that instead of targeting just the landowner who says, I don't want any wind energy on my property. I don't want any collector lines, which is what this was kind of aimed at. So they can't prevent all the other landowners from getting, if you lower it, you're making it more of a negotiating process, in my view, where I need 50%, so I need to negotiate with landowners who are not objecting to it, but they're just trying to get a little more than the other one got. And that could be good or bad, but that's the concern I would have with going too low.
Follow up.
Yeah, thank you, Mr. Chairman. Well, my concern is that you're gonna weight it too heavily with the landowners. Why wouldn't the landowners they're smart people and they can hire smart people. Why wouldn't they then take advantage of the situation, abuse it? Just in the same breath, we're talking about the utilities or whoever they may be abusing the condemnation process. What would stop them from abusing this type of a situation where they needed such a high number, of buy-in first? What would stop them from abusing it? That's really my question. Thank you, Mr. Chairman.
Mr. McGagnon.
Mr. Chairman, Senator Cole, I guess on either side, there's always the potential for abuse, but if 85% of the landowners are favorable to having the system, so long as they're properly compensated, then by refusing to negotiate in good faith, and forcing a condemnation to take place more quickly, I could see where in one sense, they may be effectively reducing the amount of compensation they can receive.
More follow-up.
Thank you, Mr. Chairman. I guess I didn't say it quite right, so I'll try again. So if a gang of landowners would get together and they would collectively decide they were not going to negotiate and agree to anything and basically never reach that threshold, right? So I don't see where that's a negative in their compensation, and they would then force the utility in this case, or whoever it may be, the individual trying to get the right of way, to in fact pay more money, basically ransom the project. That's my concern. Thank you, Mr. Chairman.
Mr. McGagnon.
Mr. Chairman, Senator Colby, I understand your concern. The other option the other possibility would be that group of landowners gets together and says, it's not about compensation. We just don't want power line across our property. And as a private property rights advocate, my position would be that if a large percentage of them got together and said, we just don't want this power line. If you're going to put a wind farm there, you go find someplace else to run your power line, that should be a prerogative of the landowners, as long as that's a widely held view of a vast majority of them.
I think Representative Davis had his hand up a while ago. Still have a question, Representative Davis?
Yes, Mr. Chairman. I was just back to that page 5E there. Thinking about everything, the conversation that is going on here, and if a commercial facility generating electricity that has purchased and pre-existing easement shall not, if that type of language could be added into there, if that would maybe prevent what Representative Slagle was, talking about.
Mr. McGagnon.
Mr. Chairman, I'm not sure that I fully understand that question, to be honest.
Mr. Chairman, just
Please.
Change of verbiage, Jim, here. If if the commercial facility that was generating electricity that had purchased or assumed, an easement from an existing utility that had a pre-existing easement, if that could be something involved in there that would protect that, I guess, extensive use of that easement by that new utility.
Mr. McGagnon.
I think I understand that.
Yeah, so what he's asking is, Mr. McGagnon, is whether we could modify the language there at the top of page 5 and say, that it essentially only applies to the purchase of pre-existing easements, not ones that are already, I think, that are already owned by the particular company wanting to put in the collector systems.
Right. Thank you, Mr. Chairman.
Yes, sir.
A commercial facility generating electricity shall not purchase.
So I think what he's trying to get at is the situation that Representative Slagle was talking about a little bit ago, which is in theory where a company wanting to put in these collector systems would go buy, for example, easements, go purchase the easements from an oil and gas company, for example, and maybe the easement's nondescript. It doesn't really say what the easement can be for, which there are some of those. They're typically old. Right? These are ones that are probably pre-50s. I've seen them in doing my job over the years. There are some. There aren't that many anymore. No one does this anymore, right? The landowners are pretty savvy. We talk about the unequal bargaining power. Sometimes I'm not sure that's true. We had a good lawyer on Zoom here a little bit ago that represents a lot of landowners in the state. And so I don't think that happens anymore. But I think there are some easements out there that have that problem, let's call it that, where they don't define what can be used on the easement. And I think that's what both Representative Slagle and Representative Davis are talking about. So your thoughts on that?
Thank you, Mr. Chairman. My thought on that would be perhaps to say a commercial facility generating electricity shall not use an existing easement for a purpose for which the easement was not originally granted. Some language like that. So if the easement was not granted specifically for collector lines here, they could not take an easement that was granted for something else and now say we're going to use it for that purpose.
So while I have you up here, I'm going to ask this question because this is the one that's going to be rolling through, I suppose, lots of lawyers' minds as they're listening to this testimony. Does that easement constitute a property right? And even if it is nondescript, does that constitute a property right that belongs to some company that can be sold to another company unless it's, prescriptively denied within that easement?
Mr. Chairman, that's a very valid question. I'm sure it would arise. I would make the argument that it's a property right to do whatever it was granted to do. I mean, if I buy a piece of property for a particular purpose, that doesn't necessarily, my property right doesn't necessarily allow it to use it for an entirely different purpose. And I think obviously that would result in a case that might end up in front of the court, but given the fact that some of those early easements were so broadly written, I think that some language that attempts to confine it would be helpful to the landowner and frankly to both parties if we're to end up in a court proceeding over whether or not a certain use fell within my property rights.
Thank you, Mr. McGagna. Any more questions for Mr. McGagna? All right, thanks for being here today. Next up, I'm gonna try to get through our public comment and then we'll take a break and then work the bills. If that works for everybody.
Good morning, Mr. Chairman, members of the committee. My name is Isaac Sutphin. I've testified before on some related issues. I am a partner at Holland and Hart in Cheyenne, Wyoming. And I do want to touch on more broadly and generally than my colleague did some of the concerns and issues that we see with both of these proposed bills. To begin with, I appreciate Mr. McGagna's use of the analogy about balancing. And I think that's exactly what we're here to discuss today. How do you properly balance competing property interest rights? And the theme for my comments will be, if it ain't broke, don't fix it. And that's consistent with what I told you when y'all met in Torrington in June. I think that's particularly true when, as here, we have a system that has evolved over many, many decades. What I didn't mention when we met last in Torrington is that really this balancing act began in 1889 with the passage of the Wyoming Constitution. There were some reference to this earlier today. The private way of necessity that is at the heart of what you're discussing with respect to these collector systems was included in the Constitution at Article 1, Section 32. This balancing act, our founders recognized the importance of competing property rights even before we were a state. And it says that private property shall not be taken for private use unless by consent of the owner, except for private ways of necessity and for reservoirs, drains, flumes, or ditches. And then it goes on to mention you can't do it without just compensation. For what it's worth, Section 33 talks about compensation. Private property shall not be taken or damaged for public or private use without just compensation. The problem with these proposed bills is that they would upset these constitutional rights. It's not a system that you really want to tinker with. And I'll touch on just a few reasons why I believe, again, that the system is working. And we've had testimony, I think, that confirms this. If we had a time machine and we went back to the ratification and the drafting of the Constitution, one of the primary factors that we would see that were at play had to do with water, which we know is a precious commodity in the state of Wyoming. These drains and flumes and private ways of necessity that are referred to in the Constitution initially were referring to irrigation canals and ditches and other mechanisms that were used to irrigate our arid land. If you were the landowner who lived on the Platte or whatever, lived on the Black's Fork, you name the river, you had access to state granted water rights. If you did not, and again, think back to 1889, you didn't have the ability to irrigate your land. Now, this was before modern irrigation and wells and things of that nature. So what was the solution? In order to facilitate development of one's property away from the precious resource, we recognize the right to take the property against the will of the guy on the river to transport the water. That is very much akin to what we're talking about now. The precious resource is our wind. It's not scarce, obviously, but the abundance of wind doesn't mean that you can just set up a wind turbine anywhere or a solar array anywhere. You have to be able to transport that and put it to beneficial use, to again borrow a term from the water world. That's exactly the same as what was recognized in the Constitution. Now, over the years since the Constitution, the legislature has waded into this balancing act. Most recently in 2007, when the act was amended to include different measures of fair market value, and we'll touch on that in a minute. My point is that the system is and does continue to work properly, and that it does address all of the issues that have been raised in the testimony and in prior testimony. Let me give you a couple of examples. In one of these bills, you heard testimony about having a potential certificate of public convenience and necessity hearing, and concerns were expressed about, boy, do we really want to force the landowners to come all the way to Cheyenne and sit before the PSC and argue about convenience and necessity. The existing system already addresses that. In any condemnation matter, one of the very first things that has to be determined is whether the project is in the public interest and necessity. We don't need to further burden our commissioners or other regulatory bodies with this. The district court has jurisdiction to hear in a condemnation case whether those pieces have been met. And if they haven't, if a company cannot prove public interest, they can't get their right of way. They can't get their easement. We talked about minimum easement standards. You heard a little bit about that. Same thing. As my colleague pointed out in 1-26-509 that lays out everything that must be discussed with a landowner as part of good faith negotiations, those things are included. Things like What's the scope of the easement? How long is the easement going to last? What is the reclamation going to be like? And all of those matters that are required to be negotiated flow through in those unusual cases where condemnations are completed. You heard a little bit about compensation. I want to just break down my views to a very simple basis. There is a constitutional right to a private way of necessity. And I believe that both of these bills invade that constitutional right and do so wrongly. There is also a constitutional provision about fair market value. To be clear, it says you can't take someone's property without just compensation. And as recently as 2007, the legislature addressed what just compensation is. It's fair market value. It is determined according to generally accepted appraisal techniques. And since 2007, that can include an analysis of so-called comparable easements. In other words, as you heard Ms. Phelan talk about, you can look at other easements on the same or similar property, and you can use that as the basis of determining what fair market value is. These new bills would throw that out the window, at least in the limited context of these collector systems. And for example, the one bill that refers to the average of what was paid for other easements, I would encourage you to consider visiting with expert appraisers and whether or not under their professional guidelines, they can even do that. Ultimately, generally accepted appraisal techniques have evolved to address the comparable easements, but I don't believe that you could fairly have an appraisal that touches on the value based on an average from other landowners. Ultimately, our view and my view is that the system is working. Landowners are either well represented or are sophisticated in their own right, as has been alluded. And the balance that we are discussing today has already been struck. I'll end on this notion of potentially 85%. In other words, acquisition of 85% of the landowners and 85% of the land. I would agree with Senator Kolb's comment that would tend to unfairly prejudice the companies in favor of the landowners and upset the delicate balance that has been established. If it's balance that we want, and if it's really a question of getting enough of the right-of-way already acquired, then there doesn't get much more balance than 50-50 or 51-49, if that be the case. But ultimately, our position is we don't think you need to get there. Sure, you will hear an occasional horror story about a company that's come in and perhaps wrongfully asserted the right to condemn someone's property and perhaps leveraged things in an inappropriate way. Those are exceptionally few and far between, so much so that especially with respect to collector systems, we are not aware of any at our law firm, as Mr. Pope touched on. Finally, to continue and conclude with the theme of if it ain't broke, don't fix it. The particular issue of existing easements and whether you can use existing easements to expand a collector system. All of the proposals that you've heard today are merely restatements of what the existing law is. Certainly to Representative Slagle's situation that he described, yes, there are easements from years ago that are not good, that are not favorable to landowners, and that have been used to expand the rights of the easement holder, and probably in many respects wrongly so. This body in 1981 passed a statute that we refer to as the easement statute. It's 34-1-141. That easement or statute says prior to 1981, those easements were whatever they were. We enforce them. The court will interpret them the way they're drafted. Since then, you cannot have an unlimited, unrestricted so-called floating easement. They're void. The statute says that on its face. And so, again, it's taken years, generations really, but our state has figured out a way to balance this. And the system functions the way it should. And my concern, as I expressed in June, is that any adjustments or changes now will have numerous unforeseen effects. And it's just not worth the risk. And with that, I'll stand for questions, Mr. Chairman.
Thank you, Mr. Setman. Representative Conrad.
Mr. Chairman, thank you. I apologize. What was that reference? 34-1-141?
Yes, sir.
Thank you.
Any other questions?
And I apologize, Mr. Chair. I should have said, Mr. Chairman, Representative Conrad. That is correct. You have that reference right. For what it's worth, that statute also includes language that if you draft an easement and you agree to it with the landowner, but you don't actually pin down the location, and it's not going to be clearly defined within 1 year, it is also void. So, I mean, fundamentally, the idea of a wide open, limitless easement, it doesn't exist. And it would not take a super sophisticated landowner or attorney to get one of those thrown out very, very quickly.
Representative Slagle.
Thank you, Mr. Chair. Mr. Sutton, question I had is a lot of us live in parts of the state that have a lot of federal land. And so my question is we allow this condemnation take place on private land for your access to get your power out or your water in or whatever you want. But why do we not go through the public land, federal land that's right next to us that that should be easier or just as easy to access as my land that's right next to there? So, I mean, that'd be my question. I mean, and that is the public's land.
Mr. Setfin. Sorry, Representative Slagle.
Mr. Chairman, Representative Slagle, I think it's a fantastic question. I've been involved in a lot of projects that touch and concern both private and public land. It is fundamentally a much bigger problem with respect to the way Wyoming and its, you can't even say it's federal land, it should be our land, right? But the federal property, the land that exists in the state of Wyoming is a huge problem. And the way that the permits, working with the EPA, for example, working with BLM and any number of other land-related federal agencies has proven not only nearly impossible, but exceptionally cumbersome and expensive. As a result, I think it is fair to say that companies developing projects look to find more cost-effective and reasonable approaches, which does lead them to the private property. We have the same issue, candidly, with respect to state property. School sections and the like pose a different challenge. Although I will say our Office of State Lands has figured it out and has figured out how to negotiate. And frankly, the underlying matter up in your neck of the woods that kind of started this involved a lot of state land.
Follow up.
Yeah, follow-up is if it's so expensive and difficult to go through these federal public lands, why can't we make it so the public has the ability through the exclusion of eminent domain to make it expensive as well? Because if it's so expensive you can't go through government land, it should be equally expensive to go through private land, other than that we're not allowed to combat you.
Mr. Setfin.
Thank you, Mr. Chair. Representative Slagle, I appreciate that clarification, and let me try to put a finer point on what I'm trying to say. First and foremost, let me say, because the way condemnation and the threat of condemnation has developed over the years, I don't mean to give the mistaken impression that it is not expensive. Projects on private property are exceptionally expensive, and I'll refer you to what Mr. Pope said about the offer for 3 times the total ranch value that was made. Fundamentally, the difference is when dealing with the federal government, It's the permitting side, the the environmental assessment, the time and money and resources that are forced to be brought to bear with respect to Clean Water Act and the like. It has nothing to do with what is fundamentally at issue, and that is the fair market value of the property sought. We heard a little bit earlier about, well, why don't we just make this fair market value based on land values in California? The taking and the value of the taking has everything to do with the land here. And so the land values don't change. It's that because the federal government has put up so many maybe I shouldn't say ridiculous, but has put up so many roadblocks in the permitting process that they have effectively pushed development to the edge of the federal property. I hope that addresses your question, Representative.
Follow-up, Representative Slagle.
Thank you, Mr. Chair. Yeah, follow-up would be is, I mean, we were talking about minimum requirements if we do condemnation. And so I guess my comment with that is I hear a lot of pushback about any minimum requirements. And that's exactly what the federal government has done to us. They put these requirements on and we're getting pushback about even having minimum requirements. And so, I mean, I guess I really see a double standard in here, how we're dealing with private individuals and the federal government. We just don't deal with the federal government because their standards are too high. But when private individuals standards start getting high, we're like, oh, you're not dealing in good faith with us, so we're going to condemn you.
Mr. Tuffin.
Mr. Chair, Representative Slagle, I think fundamentally, I would disagree. The position that I am taking is not that there should be no minimum standards. It is that the minimum standards are already in place in the Wyoming Eminent Domain Act, particularly in 1-26-509, but also in 504, which outlines the requirements in order to condemn. And that's fundamentally my point. There are restrictions, there are minimum requirements, and they are already spelled out. And to give you an example, the 2007 amendments that touched on the basis for determining fair market value resulted in years of litigation and culminated in the case that you heard about earlier, the Barlow decision. It was Green Corps v. Barlow, and then also a related decision with an outfit called Bison Pipeline. Those cases evolved over years, and respectfully, it wasn't the Wyoming Supreme Court that decided that you can do fair market value based on comparative easements. It was the legislature. And that's my concern, is that anything you tinker with will result in needless litigation that will, regardless of the outcome, will cost all of the parties and interested individuals and companies lots of money, lots of time, and really get us no further down the road.
Any more questions from the committee? All right. Thank you for your testimony today.
Thank you,
for
Mr.
being here.
Chairman.
Katie, is there anybody else online that would like to testify? All right, we're going to close public comment on this particular topic, and I think we'll take about a 10-minute break, and then we'll come back and work these bills. Are we live, Katie? All right. Thank you. All right. Committee, we're back in session and we're going to be working these two bills. What is the committee's pleasure?
Move bill.
Let's take one at a time. Representative Conrad, which one would you like to do first?
Mr. Chairman, I'd like to move 113.
All right. Do we have a second?
I'll second that.
It's been seconded by Representative Slagle. All right, so let's just go through it page by page real quick like and see if we have any proposed amendments. Page 1. Page 2. Page 3.
Mr. Chairman.
Yes, sir. Representative Conrad.
Thank you, Mr. Chairman. There's been some discussion and quite a bit, in fact, with regards to this 85 value that I don't know if we ever found the owner or the origin. What is the committee's opinion on going back to a normal, I shouldn't say normal, forgive me, 2/3 as we generally align with the majority in all other aspects?
Well, personally, I like the number 85%. I think it creates the right balance. We heard testimony about that it goes back. There was a lot of work put into that number in previous years. So I know there's other opinions and I'm happy to hear those on the committee, but just personally speaking, I like the 85. Any other comment on that? Madam Co-Chairman.
Thank you, Mr. Chairman. I would agree. I think if we, it's a little bit like when you go into the legislature, a little bit like horse trading, and I would hate to see us start at a number too low.
Senator French.
I would agree. I think we need to keep it at the 85.
Senator Ide.
Yeah, not to waste a whole lot of time. I think the higher bar, given the landowners, they've been there longer than the utility companies give them. Maybe a stronger stance on their negotiating. So I'm in favor of the 85.
Representative Banks.
Thank you, Mr. Chairman. Yeah, I would agree with the 85%. I think we talked a little bit about the balance. I think 85% of the landowners gets not quite to the balance, but a little bit against the heavy hand on the scale of the threat of eminent domain that these companies get to have.
Any other comments? Senator Kolb.
Oh, thank you, Mr. Chairman. Well, Senator Kolb has changed his mind, and I think that the 85 is probably a good starting point. I think being with the idea that, frankly, a little opposite of what we heard in testimony, but the federal government's issue, and they're running over us and granting rights of way that are going to run right over other people's individual property rights. I am very concerned about that. So I'm good with 85. Thank you.
All righty. Anything else on page 3? How about page 4? Senator Larson.
Thank you, Mr. Chairman. On line 8, after compensated, I'd like to include a comma, including terms and conditions. So it would read, any condemnation allowed under this section, the person whose land is condemned shall be compensated, including terms and conditions with consideration that is equivalent to the average.
Second that.
It's been moved and seconded. Is there any discussion on that amendment? Just have would you read it in for us again one more time for me and maybe for LSO? Thank you, Senator.
Yes. I'm not sure if it quite makes sense, but the intent is there. So in any condemnation allowed under this section, the person whose land is condemned shall be compensated, including terms and conditions with consideration that is equivalent to the average consideration given to the other owners.
Anna.
Mr. Chairman, Senator Larson, I think that might fit better On line 10 after consideration. Would that work?
I do think that might read better. I
Okay,
didn't know where to put it. So
I think it works better there.
average consideration.
So
including
I
terms
would-
and conditions.
I would agree with that. I think that's a better spot, but I have another question for Anna while she's looking at that. Does it also need to be included down below? Because there's really two different types of consideration talked about in that paragraph. Is that right? One where there's two or less landowners and one where there's more than
Right.
two landowners. So would it also need to be put down below? Maybe on line 15, something to that effect?
Yeah, I think after comparable terms.
So that, is there anybody willing to make that friendly amendment?
I like that friendly amendment, Mr. Chairman.
Does the second agree as well?
That you, yeah,
Yes, sir.
yes, and I agree. It's friendly.
Okay. Any more discussion on that particular amendment? Seeing none, all in favor of the amendment, please say aye.
Aye.
All opposed, same sign. All right, that amendment is adopted. Let's moving on to page 4. Excuse me, page 5, pardon me. Is there any proposed amendments on page 5? Co-chairman Steinmetz.
Thank you, Mr. Chairman. On line 1, page 5, before A, I would like to insert unless specified in an existing easement or infrastructure is already existing. If I can get a second.
It's been moved by the co-chairman and seconded by Representative Banks. Is there any discussion? So I like the amendment. If we're going to leave in paragraph E, I think it's helpful. This goes back to the discussion we had during testimony is, are we solving a problem or are we creating a problem? I don't know the answer. I'm worried that subparagraph E is going to cause us issues with existing property rights, not just on easements that maybe are old and vague, but even on some of the newer ones that maybe aren't old and vague. I don't think when we were drafting this bill, I did not think about that, to be honest. I don't think any of us did. That was not the problem. That's not what we were trying to address. And so I guess if we're going to leave in E, I'm in favor of the amendment. If we're going to take it out, obviously we don't need that particular amendment. So those are my thoughts. Committee? Senator Kolb.
Mr. Chairman, I think we don't need E. So I'd be in favor of striking E.
Representative Slagle on the proposed amendment.
Thank you, Mr. Chair. Yeah, I would be in favor of this amendment. I really think we need something in there addressing prior easements.
Madam Co-Chair.
Thank you, Mr. Chairman. And I've heard from some constituents across the state. I mean, they're not my constituents, but some county officials that say this is a problem, that they're seeing piggybacking on old existing easements for projects that weren't necessarily what was contemplated and what the easement was for in the beginning, and that it's a problem. And I think this addresses it. It may not be perfect yet, but we have a long way to go to get it through the process. So I'm in favor of it, obviously.
Any other comments? All right, seeing none, all in favor of the proposed amendment, please say aye.
Aye.
All opposed, same sign. That amendment has been adopted. Any other amendments on page 5? Representative. Okay, any other on page 5? Page 6, any proposed amendments? Representative Conrad.
Mr. Chairman, thank you. I apologize again in advance. I'm still unclear, and I apologize. Lines 4 and 5. Are we, based on this dormant climate clause, I think that was the name of that matter that was spoken about, with that export energy from Wyoming? Can someone clarify that? What are we intending here? Is it strictly exporting? Is it internally? I guess, help.
So as I read it, Representative Conrad, what we're saying is that this particular provision does not apply to existing lines that are already exporting power out, or lines that have already been planned to export power out of the state of Wyoming. I'm not sure that, because of the way it's written, I'm not sure, and it's the dormant commerce clause, so it's the inverse commerce clause, but which is it's based on case law out of the United States Supreme Court, but I don't think we're getting into it because of how it's written. I think that's the point of this, is we're saying we're not trying to apply it to power lines that are already exporting power out of the state or that are planning to.
Thanks.
Do you have a proposed amendment?
No, I don't. I just want to make clear when this moves forward, we can explain it, obviously, as members of this committee, that this is for existing, but not future, and we do not impact the dormant commerce clause.
And so I don't think we probably don't. I don't think we need to do anything. I do see a typographical error on line 4, which I believe Anna can just fix. I think should be or, at least on the bill draft I have.
Yes, I can fix that.
Any proposed amendments? Sorry, Senator Kolb.
Yeah, thank you, Mr. Chairman. So getting back to line 4 on the export, why do we need that? Export energy from Wyoming. Why is that necessary to put in there? I mean, what are we accomplishing by that?
Madam Co-Chairman.
Thank you, Mr. Chairman. It's what we're excluding. So it says on line 2, but not including. So I think it may actually be get us around the commerce clause, because we're talking about, we're not going to do it for lines that export energy from Wyoming. These are collector lines we're dealing with, not the main transmission lines. And so I think we're just excluding that. But if Anna, would we like to bring Anna up for more clarification? Do we need that as a committee, or Mr. Chairman, what's your pleasure?
Well, I think you're right. That's the whole point of that provision, is that we're excluding large transmission lines from the definition of collector. And that's really what we're talking about. If you turn back to page 5, we're talking about the definition of a collector system. And so that the co-chairman's exactly right. We're just excluding that from the definition so that it's clear within the statute.
Do any collector lines go across interstate boundaries?
They may, but this is that's why the further definition of exporting from the commercial facility, I think that's why that has to be in there. Any other questions or comments on that particular page, page 6? All right, Senator Ide.
Thank you, Mr. Chair. On page 6, line 9, I brought this up earlier on, defining a commercial facility generating electricity. I think a lot of this legislation is directed at so-called renewables that really aren't renewable. They still take mining of silver and legacy oil and gas industry stuff to even make this stuff. So they're really not renewable energy. So, and I've always got a problem with getting away from free market principles. When you subsidize these projects, I don't think we would probably see any windmills right now if they weren't, funded by the taxpayers by some form of subsidy. And defining subsidy is a tricky thing, but I've got some proposed language here that I'd like to have the discussion on, and it would start at the end of line 9, where it says generating electricity from any source, take the period out, that has not received any state or federal monetary taxpayer subsidies to make the project commercially viable. So that's, I think I'd always like to get this into discussion, whether anybody likes it or not. We need to get away from, just all of the stuff that our children and grandchildren are going to have to pay
Senator,
by.
Could you just, we'll get into discussion in a minute after the second,
Sure.
but could you repeat the language you want in for all of us? Thank you.
So at the end of line 9, after source, it would continue on to say that has not received any state or federal monetary taxpayer subsidies to make the project commercially viable. I'll end with that.
Is there a second? Representative Slagle with the second discussion. So I have a little bit of discussion, and I don't disagree with the concept, but I think this will have the amendment would have unintended consequences, because what that will do, it will, any entity that does not take government subsidies will not be subject to this law. So that means they could condemn outside of this law because if they don't take subsidies. So I'm not sure we want to put that definition in there, because it will, I think, counteract exactly what we're trying to do because of how the definitions work throughout the statute, Senator. So I'm a little bit nervous about that. I agree with the concept and what you're trying to do, but I don't think we can put it there because it will exempt all sorts of companies from this part of the eminent domain law. Senator Kolb.
Thank you, Mr. Chairman. Could we work that language and see if we can put it in this bill somehow that doesn't affect it in that negative way?
I don't know. I mean, I think that's going to require a lot more thought probably on where to put it. I just don't, I just know we can't put it. I shouldn't say we can't. I don't think it's a great idea to put it there, because I think it will just eviscerate the whole purpose of the statute when we start talking about because there will be companies that in the future that maybe don't take subsidies. And if they don't, then they don't have to follow the law, the proposed law. I don't know where we could put that, Senator. I'm willing to listen. Senator Ide.
Thank you, Mr. Chairman. You know that you made some good points there. I have to agree. However, I'm not sure that anybody would do any of these so-called renewal projects if they didn't get subsidies. I think we'd be pretty safe to do it in there because they're not commercially viable. And with that, I don't see how this would affect anybody. I think everybody that's going to be using this is going to be a subsidy sort of a project. So thank you for your comments.
Senator Kolb.
Yeah, Mr. Chairman, but the existing law that we have now with right-of-way would still exist if it was excluded from this bill because, say, it was taking government subsidy. It wasn't taking government subsidy money for the project. All the existing law that we currently have would still be in effect, wouldn't it?
It would, but under existing law, any of those can use the power of eminent domain to condemn private property. What we're trying to do is create a balance where they have to show that they've negotiated with 85% of the folks before they can use the power of eminent domain. Right now, they don't have to do that. And so it would not apply. The other thing, I guess, in response to what Senator Ide was just talking about, this bill does not apply only to renewable type energy sources. This bill, as it's written, would apply to traditional energy sources as well, coal, etc. And so they would be much more likely to be exempted out of it with that amendment. Does that make sense, Senator Kolb? Probably not, but. Representative Davis.
Thank you, Mr. Chairman. I did have one question. In recent history, we had the coal bed methane boom up there in your country. and it was subsidized. And when they all went bankrupt, we had a bunch of orphan wells that the state of Wyoming was in charge of reclaiming and all this other infrastructure. So I think maybe there needs to be some room or somehow wordsmith this in there, because that was a subsidized industry that wouldn't have existed without the subsidies.
Anything else from the committee? All right, if there's no further discussion, we need to. Madam Co-Chair.
With your permission, I thought I might check with staff to see if they knew of a place that might fit better in the bill. Just Anna's been working so hard on all of these bills for us, and we appreciate you and thank you for that. And she knows them like the back of her hand by now. So with your indulgence, Mr. Chairman, maybe we could check in with staff.
Thank you.
You're welcome.
Mr. Chairman, Chairman Steinmetz, I'm not entirely sure where that would fit in the bill, to be honest. It would kind of change the trajectory of the bill. And I, like Chairman Crago said, it might change the purpose of the bill as it stands. I'm not entirely sure where it would fit, and I'm sorry.
Follow up. Yes, please.
Mr. Chairman, thank you. Senator Ide, I completely agree with your concept and the thoughts. I'm wondering if maybe we should work on an individual bill at this point, since the committee's done so much work on this, and I completely agree with what you're going for. I'm just not sure technically that it's going to work in that spot, and I would hate to damage what we're actually trying to accomplish.
Senator Ide.
Thank you, Mr. Chairman. I think that is the right route to go, is on a separate bill on this, because it changes the complexion of this and adds some damage to it. I think after hearing the debate, that's kind of why I wanted to get it out there. And yeah, if we want to do something later on that, so I'll move that just to pull my amendment.
Withdraw your amendment. Does the second agree? All right. Do we have any more amendments on this bill on pages 7 or 8? Any other discussion on the bill in general? Senator Kolb.
Yeah, thank you, Mr. Chairman. I'd like to bring up the idea that we involve the Board of County Commissioners with any action within the affected counties when it comes to commenting with the PSC. In my mind, that they have to be requested to have their consent upon a project. I guess I wouldn't think it would be the end of the project, but I think they need to weigh in at a different level. Many counties already have a permitting process that they go through. Other counties do not. And this is an overall, an overall look at what we can do for the state of Wyoming to give the counties another voice at the PSC level. I think they can take care of their own level. If they choose not to adopt zoning policies within their county, that's their choice. But I think those elected officials do represent the people directly. And I think their opinion is important. And that's why I think they should be part of this equation about a condemnation process.
Senator, do you have a proposed amendment or an idea where you would?
I don't know where it would go properly. That's why I kind of waited to the end, Mr. Chairman. But I said, what I have written down here is that PSC shall request the consent of any Board of County Commissioners for a project in that it physically impacted county in order to condemn any rights of way. I don't know where it would be inserted. I think that's probably an LSO question, Mr. Chairman. I don't know if it fits in. I just think that the Board of County Commissioners, because they are connected to the people, should be involved in a better way than they currently are.
And so I think what we're really talking about, because this particular bill does not address PSC. I mean, what it talks about is a certificate of public convenience and necessity, which we're not really addressing. We're saying those entities are exempt. And so maybe that's an idea for, I don't know, a different bill. I'm not sure it fits within this statutory framework because what you're talking about is how an entity can go get the certificate. Really, I mean, that's the only reference to the commission within this bill is acquiring that certificate.
Yeah.
I don't know where it would fit in here. I guess we could ask Anna that question as well, but it's something we could look at separately too.
A sign off on a certificate then. A sign off on a certificate. The Board of County Commissioners. Let's forget about the PSC and just say that they're involved with agreement in the certificate.
Well, I don't think we can forget about the PSC because they issue the certificate. There's an entire hearing process to go get that certificate, and you have to go through them, would not be through the courts or anything else. And so I don't know, I'm just having a hard time visualizing where that goes in this
Well, that's why
particular statutory framework.
If there's no vehicle to get it there, then there isn't.
I would say there probably isn't, but we can ask Anna if she could think of a way to sneak it in.
Chairman Crago, Senator Kolb, I'm thinking if we put it anywhere, it'd be on page 2 on line 12. Or line 13 after necessity, we could maybe put it there. But it does sort of change the landscape of the bill too.
Senator.
Yeah, then I withdraw it. I just think it was valuable to discuss this. And because it is a valuable, issue with local localities.
I totally agree. I don't think we're done discussing this issue with this bill. I mean, I think this is going to be something we work on next interim as well, to be honest. And I think that's one of the things we put on our checklist. Let's talk about that. Let's actually have the county commissioners here because there's some other things we've talked about today that aren't going to be addressed with this bill. And we just need to keep them in the back of our minds as we go through session. And when we have our interim topic meeting, let's put it on the list. All right, anything else? All right, Katie, would you please call the roll?
Mr. Chairman, this is roll call for 24 LSO 0113 Eminent Domain Energy Collector Systems as amended. Senator French.
Aye.
Senator Hicks, excused. Senator Ide.
Aye.
Senator Kolb.
Aye.
Senator Larson. Representative Alaman. Representative Allred.
Aye.
Representative Banks.
Aye.
Representative Conrad.
Aye.
Representative Davis.
Aye.
Representative Slagle.
Aye.
Representative Winter.
Aye.
Chairman Eklund.
Aye.
Chairman Steinmetz. Vice Chairman Crago.
Aye.
14 aye, 1 excused.
All right, and so with that, we have one other bill on our agenda. I don't know if we care to move that forward. As Anna explained to us earlier, the bill we just passed essentially repeals that provision of the statute. And so I don't know if it's necessary that we take that up today, but if the committee wants a backup or something, we can sure do that. Co-Chairman Steinmetz.
Thank you, Mr. Chairman. And I'm wondering if we shouldn't take a look at this and consider passing it as well. We don't know what the temperature of the legislature is on this subject and which direction we may end up going, and it might be prudent to advance both bills so that we have kind of an option for people. I know that Chairman Case has dealt in this area for a long time on the Corporations Committee. He was the one that brought this bill to us and has done extensive research in this area. And so I think we need to consider that as we move forward. And I'd love to hear discussion from the rest of the committee as to what their thoughts are on the bill.
Co-Chairman, do you want to move the bill and we'll get a second and then have some discussion?
Mr. Chairman, I would move LSO 24 123.
Is there a second?
I'll second it.
Representative Slagle seconded the bill. Is there discussion?
Mr. Chair.
Representative Slagle.
Yeah, I agree with Senator Steinmetz. I really think this is an issue that we need to kind of have all of our options on the table, because as we move forward, if we lose one of them, I mean, there's a term that I heard a lot down in legislative session. We'll have more than one horse in the race, and I think this is the deal. And I understand the deal. If we get 113 through, then it deletes this one, but at the same time, we've got them both there until we decide which one we really want to use. Another comment, I think if we move this forward, we also need to put the amendment on page 3, lines 1 through 4. We need to add the amendment that Senator Steinmetz put on the other bill.
Is that a motion?
That is a motion. I move that.
Second.
It's been moved and seconded. Is there any discussion on the proposed amendment, which is the mirror amendment from the other bill? All right, all in favor of the amendment, please say aye.
Aye.
All opposed, same sign. That amendment has been adopted. Is there any other discussion on the bill? Any other proposed amendments? All right, seeing none, we'll proceed to vote on 24 LSO 123. Katie, would you please call the roll?
Mr. Chairman, roll call for 24 LSO 0123 eminent domain energy collector systems amendments as amended. Senator French. Aye. Senator Hicks. Excused. Senator Ide.
Aye.
Senator Kolb.
Aye.
Senator Larson. Representative Alaman. Aye. Representative Allred.
Aye.
Representative Banks.
Aye.
Representative Conrad.
Aye.
Representative Davis.
Aye.
Representative Slagle.
Aye.
Representative Winter.
Aye.
Chairman Eklund.
Aye.
Co-Chairman Steinmetz.
Aye.
Co-Chairman Craigo.
Aye.
14 aye, 1 excused.
All righty. We are way behind schedule, thanks to me, so I apologize. Our next topic is federal land use plans and statutory changes, and I believe we have LSO to visit with us about bill draft 24 LSO 254.
Mr. Chairman, members of the committee, this is 24 LSO 254, Federal Land Use Plans Legal Action Authorized. This bill draft would amend Wyoming Statute 28.8.114, beginning on the top of page 2. This bill draft declares that the legislature has a sufficient interest in the proper interpretation and administration of several environmental federal acts, which are listed in the bill draft, which provides the legislature standing to prosecute an action for declaratory judgment to protect its interests and the interests of the public. Subsection C on page 2 declares that the legislature shall be considered a cooperating agency for purposes of the environmental federal acts listed in the subsection. Then the staff comment on the top of page 3 indicates that most federal acts require the cooperating agencies have a written agreement with federal agencies, and the federal agency would have to declare the legislature as a cooperating agency in order to have that status. This is not something that can just simply be declared in statute. Also, the legislature may not qualify as an agency as the term is defined. That typically refers to executive branch agencies. And then federal acts are added to the new subsection D on the bottom of page 3. And the end of the new subsection D declares that the legislature shall have standing and may establish a fund to prosecute actions for declaratory judgment. Then section 2 in the middle of page 4 provides for an effective date. And I would stand for any questions.
Questions from the committee? Representative Conrad.
Mr. Chairman, thank you. On page 3, there's a note here in the staff comment. I just want to understand it completely. An eligible government entity must have a written agreement with the BLM. If we pass this and they decline to establish or give us a written agreement, we're still left out, correct?
Correct. Chairman Crago, Representative Conrad, I believe that's correct.
So the impetus of this is really, Mr. Chairman, sorry.
Yeah, we'll follow up.
Thank you, Mr. Chairman. The desire of this is, as we speak, I think, related to the most recent issue with the Rock Springs BLM RMP, correct?
I believe this was in response to that. Yes, I'm sorry. And I'm sorry, Chairman.
It's all
Crago.
right.
I apologize.
Get going. We're late for lunch. All right, follow up.
Thanks for the follow-up, Mr. or rather Chairman. I guess my question is to the group, more importantly, this committee, if the BLM, I mean, they could just blow us off, for lack of a better Southwestern term.
For lack of, Chairman Crago, Representative Conrad, for lack of a better term, I believe that's probably true.
Thank you.
So I got some questions down here, but one quick question. Do you know if any other legislature has cooperating agency status?
Chairman Crago, as far as I know, no. And we've actually discussed this within the office a little bit. Nobody's ever found any case law or anything to having to do with legislatures becoming cooperative agencies either. So.
Do you know, well, strike that. Senator Ide, did you have a question?
Thank you, Mr. Chairman. The question I have, Anna, is paragraph A of this statute is not on here, but at the last sentence of paragraph A of 28.8.114, it says, let's see, an administration of the Constitution and its own enactments to provide standing for the legislature to prosecute an action for declaratory judgment, protect its interests and interests of the public. Is that, when they refer to the Constitution there, are we just referencing the Wyoming Constitution, or is that the US Constitution as well?
Anna?
Chairman Crago, Senator Ide, I believe it's just the Wyoming Constitution.
Thank you.
Any follow-up? All right. Any other questions for LSO on this particular bill draft? Senator French.
Thank you, Mr. Chairman. Can we add in this that something along the lines of the legislature requests cooperating agency status from the federal government? Can we add it in this bill that we're, along with what's in here, we're requesting that?
Chairman Crago, Senator French, I believe that's a policy question, but you probably could add that in.
Anna, is that something we also could do by separate resolution?
Yes.
Okay. Co-chairman.
Thank you, Mr. Chairman. So if you, we all remember the last meeting, and we had, since we're having a discussion here, and, you know, the BLM came before us and the issues we're now having with them, and they basically kind of have blown us off already. And it was just an idea, because we started talking about it, right? It seems like we don't have much of a voice at the table. We did send our letter. We're thankful that the public comment period was extended, that the governor jumped on board, and many other committees and legislators as well have jumped into the fray on this, and we're thankful for all of those actions. I'm wondering, after really looking at this in a more holistic approach, if cooperating agency status is a lesser degree of what the legislature actually possesses under both their the United States Constitution, the Act of Admission, and our duties as an actual legislature and the representatives of the people of the state. And so I've got some thoughts and ideas that we might be able to take the cooperating agency status out and just assert our jurisdiction if we decide to, when we get to that point. So with that, I mean, I just wanted to add that in, because it has been a heavy lift, and thank you to staff and Anna to try to get a bill of this scope and magnitude prepared in between our meetings, because it wasn't a very long period of time, and this issue was sprung upon us very quickly. And so as we work through this, There might be a lot more to come, but those are just my thoughts after working with Anna and the vice chairman here, our good chairman today, of what we're kind of seeing in this bill, or what I am anyway.
Representative Davis.
Thank you, Mr. Chairman. Yeah, you know, looking at all the agencies that do have cooperating status, and as you put, you know, they were all, their input was just, for lack of better words, blown off too, you know. I don't know what this really achieves us cooperating status as the legislature. You know, there's got to be a different tool that is available to us to attack this problem, I would think, other than this piece of legislation.
Thank you, Representative Davis. Any other questions for Anna? Senator Ide.
Yeah, just one quick follow-up to the first question that made me think of it here. So a lot of the reason this statute was requested was for the reason that the U.S. Constitution in Article 1, Section 817, it requires the consent of the state legislature to approve land sales to the federal government from private to federal, which they're effectively trafficking in state sovereignty by that. And that's what we were originally looking for, you know, a mechanism, so to speak, if the executive branch wasn't going to take it on, that the legislature had standing to argue something that harmed the legislature, because that's where the authority came from. So in the state or in the U.S. Constitution. So would this, in your mind, apply to that in that instance? Thank you.
Anna.
Really what we were looking at in this particular bill were these federal acts, not necessarily land sales. So I don't necessarily know that that would apply to this particular bill.
Follow up.
Thank you, Mr. Chairman. Apply to the bill as amended here or the original statute?
Oh,
thank you.
Anna.
I'm just trying to recall what the original statute said. I know that what we're looking at now just deals with these federal acts. I'm not sure that subsection A applies to federal or the federal government buying land from the state of Wyoming.
Any other questions for LSO? All right, so let's move on to public comment regarding this particular topic. Do we have any public comment here in the room? All right, do we have any public comment online, Katie? All righty, we're quickly catching up to schedule. This is good news. Committee, what's your pleasure?
Let's move the bill, Mr. Chairman.
Second.
It's been moved by Representative Conrad and seconded by the co-chairman. Is there any discussion on the bill? Representative Conrad.
Thank you, Mr. Chairman. I guess in this case, I'm struggling with this word cooperating. It's an oxymoron for me, at least in the southwest corner right now. Does that need to be there in this language, cooperating?
Co-chairman Steinmetz.
Thank you, Mr. Chairman. Mr. Chairman and Representative, I have an amendment that might take care of that. If you would allow me to move an amendment, and then it might take care of your concerns.
Please.
Okay.
I'd like to allow that.
Thank you, Representative Conrad and Mr. Chairman. Okay, so I've kind of worked this thing over, and you know, it's up to you guys if you want to go this route with the bill, but this is the only way I can see going forward, because I'm not willing to concede that we're a cooperating agency. We're a state legislature of a sovereign state. And I think we're all tired of being blown off. So, I think on page 2, line 5, after the legislature finds that, insert or delete proper interpretation of, and that'll go on to line 6. And then we would insert, and this is kind of long and I'm sorry. The United States Constitution in Article 1, Section 8, Clause 17, and Article 4, Section 3 recognize jurisdiction of the Wyoming State Legislature over land within the boundaries of the state of Wyoming. The Wyoming Act of Admission in Section 1 recognizes that the state of Wyoming is admitted into the Union on equal footing with the original states in all respects, whatever. And so that would be the first part of the amendment. And then we would create on line 6, a new subsection C. The legislature finds that. And then we would delete all of line 17 through 22. And we may even want to insert that the legislature being a co-equal branch of government. Somewhere in there, it's just a thought that came to me after I'd written all of this out late last night, but we are a co-equal branch of government. I know there's always issues about separation of power, but this is the statute that we've given ourselves to prosecute, to have standing and to litigate on behalf of the citizens in the state of Wyoming. And so I think it's important that we start to regain and recognize the authority of the Wyoming State Legislature. And this situation has brought to bear a real need for that in Rock Springs and in our dealings with the BLM and this current administration. And so that would be my amendment if I could get a second.
I'll second.
Since he's closest to me, Representative Conrad has the second. I heard that one first. Didn't travel that fast from down there. So it's been moved and seconded on that amendment. Do we have some discussion on the amendment or do we need the good co-chairman to read it in one more time? There was a lot of language. Anna, did you get it? Okay. All right.
Mr. Chairman, I will hand deliver that amendment to our staff, and I would be glad to reread it if you would like me to.
I looked at it over your shoulder, so I'm good with it, but anybody else on the committee want to hear it again?
Yes.
All right. Representative Allred says he'd like to hear it one more time.
Well, I thank you for the opportunity, Representative Allred. I will be forever in your debt. Okay. On line 5, we are going to delete proper interpretation, and line 6, delete the word of. And after that, we are going to say the United States Constitution. So it will read, the legislature finds that the United States Constitution in Article 1, Section 8, Clause 17, and Article 4, Section 3 recognize the jurisdiction of the Wyoming State Legislature over land within the boundaries of the state of Wyoming. The Wyoming Act of Admission in Section 1 recognizes that the state of Wyoming is admitted into the Union on equal footing with the original states in all respects, whatever. So that would be the subsection B. And then on line 6, we deleted of, we would insert subsection C and just the legislature finds that. And I would also amend that to say the legislature as a co-equal branch of government finds that. So that would be the amendment. I'll just slip it right in there. And if my second would still agree with the co-equal branch of government language.
Yes.
And so with that, that is the amendment. Oh, and I did wonder, well, we'll deal with this later, but that's the amendment.
All right. Any discussion on the proposed amendment? Senator,
Oh, yes, and Co-Chair, or Mr. Chairman, I forgot to tell you to delete 17 through 22. My good Vice Chairman on the Senate side reminded me. Thank you for that. So we would delete the current subsection C 17 through actually 23. It's a blank line, but that's what would be deleted.
Senator Ide.
Thank you, Mr. Chairman. I'm in favor of that amendment. I think it's a great replacement for what we have in there right now. It's a lot stronger. It gets to the point. It's a little broader. So I support the amendment.
Any other? Representative Banks.
Thank you, Mr. Chairman. I too support the amendment. It defines the role of the legislature as outlined in the United States Constitution, and I appreciate that we're putting that out forward, that this is our responsibility. We have the standing, we got to go forward with it. And I think it gives us more language than it would just being blown off as a cooperating agency that we've been seeing with the BLM. So thank you.
Any other discussion? So I just have a little bit. I like the bill as drafted. I also like the amendment of taking out the cooperating agency status provision because I don't think we need that. I think if we can be a cooperating agency, we can do it without us putting it into the law. I agree with the first part of the amendment. I mean, I agree with all that's written. I just don't know if it needs to be in the statute. Because really what we're saying is it's more of a policy statement. It's not really a law. We're just saying what we believe. We're not saying what we can or cannot do, or as the legislature. That's in part B, which would then become part C, which is, I think, the intent and the heart of the bill, saying, hey, we can bring actions on behalf of the legislature to prosecute some of these lawsuits, I guess is a better way to put it. We can bring these lawsuits to talk about all of these different agency actions, and especially regarding lands within the state of Wyoming. I just don't know if we need the first part, although we all agree on it. My question is, do we need that part of the amendment because again, it's a policy statement. It's almost like a resolution. We're saying, hey, we believe this. Does it harm anything? I would say no, except the rest. Does it then cause problems with the rest of the statute? And are we limiting ourselves on what we can do with the already existing part of the statute, which allows us to bring general lawsuits to protect the interests of the legislature? I don't know. I think that's my only question with it. It's not that I don't agree with it. I think all of us on this committee agree with what the good co-chairman has written. My question is, from a statutorily point of view, are we creating any issue there? I don't know the answer. I'm just throwing that out there. Representative Alaman.
Thank you, Mr. Chairman. I really appreciate this amendment. And as the oath that I took last year going into the House, I've got to vote for it. Thank you.
Representative Conrad.
Mr. Chairman, to your question, I think it would behoove us to leave it in there at this point and allow the bill to move forward. That's just my opinion.
Leave which part in
I'm sorry, Mr. Chairman, the entirety of what the co-chairman Steinmetz has mentioned.
And I don't necessarily disagree with that. I just bring it up for a point of discussion. It's something we can think about, mull over between now and session. And once it's in the bill draft, we can see. I mean, we can always, if we get to session and decide, hey, this is going to cause us more problems than we anticipated, we can always take it back out. I'm just throwing that out for discussion now so we can think about it. Senator Kolb.
Yeah, thank you, Mr. Chairman. I think as long as we put language in there that would say that this bill will not detract from any current abilities the state has, and just limit it so it cannot be interpreted as limiting something we already have authority to do if we don't yet even know what that is. I think can we put a backstop on it just to say that that the intent of this bill is not to limit us in any way from our current abilities. It's just, I mean, some way of not having it be a detraction to what our current I mean, that sounds like it was your concern that we would somehow limit our ability to do something in the future.
So my only concern is, does it unduly amend in theory, the provision we already have, which is subsection A, which gives us very broad powers, actually. I mean, there could be an argument, we don't even need this bill because of subsection A. The point of this bill, I think, was really to point out, we as the Ag Committee believe that we do have the ability under subsection A to, institute some of these actions regarding those specific things set forth in subsection B. That was all I was getting at. I don't think we need additional language to that effect. Just throwing it out there because I don't really know where you would, to be honest, how we would squeeze that in or where it would go. But I appreciate the thought because it's not a bad idea. So follow up, sorry.
Yeah, just follow up. It's a political statement to react to what's going on. And I think that's well within our ability to do this. And that's why I support it. Thank you.
Madam Co-Chairman.
Thank you, Mr. Chairman. I'll try to bring us home. So subsection A is broad authority in that same section of 28.8.114. And this is just, to me, this is us asserting our jurisdiction. And one of the things I learned last session when we had our good training with some of the Supreme Court justices is they really like to look at legislative findings. They like to look at things that will help them determine what the intent of the legislature is. And so I think that asserting our jurisdiction is appropriate in this manner. Thank you.
Anything else from the committee? Any other proposed amendments or discussion on this particular bill? Representative Conrad.
My apologies, Mr. Chairman. Since we have struck or proposed to strike page 2, line 17 through 23, would it be appropriate then to delete on page 1, line 4?
So pardon me, I got ahead of myself. We need to vote on that amendment first. I apologize. So let's do that first. Anna.
Chairman Crago, Representative Conrad, I believe you're referring to the D and E and all that? Or no?
No, Mr. Chairman, I think to our good co-chairman, I think it will be addressed once we do go through the amendment and then once I get to the bill.
Okay.
All right, seeing no further discussion on the proposed amendment, all those in favor, please say aye.
Aye.
All opposed, same sign. That amendment has been adopted. Anything else on the bill? Madam Co-Chairman.
Thank you, Mr. Chairman. I just would like to have some discussion. So for discussion, I'll move it. Line 15 on page 2, protect the interests and the interests of the public. I'm wondering if that should be of Wyoming because what is the public? Are we the federal government or the public at large who might be looking at this? So I'm wondering if that should be Wyoming. I'm not torn either way, but I'm thinking that might be something for our consideration.
Is that a proposed amendment?
I'll propose it as an amendment for discussion.
Is there a second?
I'll second it.
Representative Slagle with the second. Any discussion? Senator Cole.
Yeah, just to deal with that interest of the public statement, how about the interest of the state of Wyoming?
I would consider that a friendly amendment. Would my second?
Any other discussion on the amendment? Representative Conrad. Any discussion on the amendment? I have one quick question for Anna. Does that language mirror language from any other part of the statutory framework for this particular area of law, i.e. Title 28? I was trying to look it up, but I couldn't get there fast enough. I'm sorry.
Chairman Craig, I'm looking at it right now and 28.8.114A says interest of the public.
And so it was crafted to mirror that.
Right.
Senator Kolb.
Yeah, Mr. Chairman, just then, so that would we have to consider the public being anyone in the United States? Or just to be, it's known that it's anyone here in the state of Wyoming? That's my question. The public, what is the public referring to? Is it broadly the public all over the US world? Or is it just here in the state of Wyoming?
So the way I read the statute, we're limited to dealing with Wyoming issues as the legislature. I mean, that's in fact, subsection B talks about specifically plans within the state of Wyoming, and it uses the terminology are matters of great public interest. And so I understand why LSO used the term interest. I'm not sure I'm in favor of changing that, because then we're going to have different terminology between A and B. And so if we're going to change B, then we should probably change A as well. Senator Kolb.
Mr. Chairman, I withdraw.
Okay.
Mr. Chairman, I'd like to withdraw mine too.
And does the second agree? Okay. Moving on, any other proposed amendments on this particular bill? All right, Representative Conrad.
Thank you, Mr. Co-Chairman. Just on line 1, or I'm sorry, page 1, line 4, I would propose an amendment that says authorizing the legislature to be an agency and deleting cooperating, since that would align with the deletion of the cooperating component on page 2, line 17.
So Representative, I believe that will happen when that's a conforming amendment, and that whole line actually will come out, because we're not declaring ourselves to be an agency, because we are not. Under state statute, we are already excluded from being an agency. So I don't think we need that particular amendment.
Good, thank you. I withdraw that amendment.
All right, any other discussion? Senator.
Thank you, Mr. Chairman. I've got another amendment, if that's appropriate time to bring it up right now.
This is the time.
Okay.
Please.
On page 3, line 26, and this ties in with Chairman Steinmetz's original amendment to this bill, to this statute. So it would read now, you cross out or, so it would say rules. Let's see, statutes, rules, federal acts, or federal purchase of lands within the state.
Is there a second for that? Representative Slagle is the second. All right, any discussion on the amendment? Senator.
Thank you, Mr. Chairman. I'll be just brief. I think this is short, simple. It ties it in with what we had in that First Amendment. And this is sort of what instigated a lot of the discussion on this statute is, the violation of the consent of the legislature for purchasing lands within the state regarding the purchase in Natrona, Carbon County of recent times here. And so that would just clarify this, that it pertains to the purchase of federal land, purchase of private lands from the federal government. Thank you.
Any other discussion on this particular? Senator Kolb on the amendment? All right, anything else on the amendment? All right, all in favor of the amendment, please say aye.
Aye.
All opposed, same sign. That amendment is adopted. Senator Kolb.
Mr. Chairman, would it be appropriate? I think it would be to put an appropriation onto this bill.
It could be, but I don't know what that would look like. And the reason I say that is unless we're just going to set up a fund that sets there for the purpose of prosecuting these actions, we can't really pick a dollar amount. We don't know what they would cost, but you could put an appropriation to put a long-term fund somewhere. I don't know where that'd be held, but that's a theory, an idea.
Well, Mr. Chairman, I think this is going to require money. Let's just say this gets perfected, moves forward, and we have to take action. I think it'd be a statement, number one, of the support of this committee that we, are in favor of this action. And with that, it's going to involve a money amount. And I think it's appropriate that we would set aside $50 million to fight this and litigate this in the future. Now, that's a placeholder, but I think it conveys the seriousness of this matter and the seriousness of what this bill's trying to address, Mr. Chairman.
Is that a proposed amendment?
That's a proposed amendment.
All right, all right. Representative Alamand has the second on that. He raised his hand the highest down there. Yeah, there was, I didn't know, thought we might have a fist fight down there to see who gets the second that. All right, so we have that motion. It's been moved and seconded. Is there discussion on the appropriation? Anna, do you have any questions on that for your purposes?
Chairman Crago, do you want to create some sort of a fund that doesn't revert back at the end of the biennium, or how do we want to do this?
I think that was the intent of the bringer of the motion, yes.
Okay, I think I understand then.
Okay. Representative Banks.
Thank you, Mr. Chairman. I appreciate the bringer of the motion, bringing this appropriation into this bill. We need to make a statement. And this is going to say that we're serious about the issue and we're serious about the public lands in Wyoming. I don't see anything we can do now stopping the proposals going forward. So it's my opinion, we're going to end up in the courts and we're going to need the money to litigate it. So I support the amendment and support the statement it makes, that we're serious about protecting the public interests of Wyoming.
Representative Slagle.
One question one question I would have is, the legislature's already set aside funds for the governor to litigate. Is there a way that if the governor doesn't litigate, the legislature would have access to those funds?
Well, Representative, I think we have access to all the funds because we are the legislature, but it depends on, I can't remember exactly how that particular law reads, whether that reverts back to us for reappropriation or not. Someone else on the committee, maybe one of the good former appropriators would know. I don't know the answer to that, but it just depends on how that particular statute reads. I don't know if that's for purposes of today. I don't know if it matters. If we're just setting up an independent fund, then we just probably go that direction. Representative Alamand.
Thank you, Mr. Chairman. Would this amendment allow for outside counsel? Okay, thank you.
Co-Chairman Steinmetz.
Thank you, Mr. Chairman. So to answer that, I don't believe it's the FNRPA account and I don't believe that it reverts. I think that we reappropriate every year. And in fact, that's one of the letters we sent this year to make sure that fund is fully funded. However, and obviously the legislature has access to all funds, but if we want to join the governor in the lawsuit or want to litigate something on our own, this would provide for that because we can't just go in and management council decide to use the FNRPA account. That's the governor's disposal. And this provides for a way that management council can act on our behalf to litigate when situations arise. So this would give them a fund to tap, to use outside counsel and to litigate on behalf of the legislature, if that helps.
It does. Thank you. Anything else? Any other amendments? Any other discussion? Senator.
Thank you, Mr. Chairman. I just want to voice my support of this bill. I think the comments made by the good representative from Bighorn County, we need to show strength here. And I think this kind of sends a message that we're getting locked and loaded to not get pushed around anymore from the big guys back in DC. So thank you. I'm in favor of this bill.
Senator Kolb.
Well, thank you, Mr. Chairman. I think what this does is sends the message that what we're doing, we're serious about. More importantly, though, we're risking billions of dollars with the state of Wyoming if the Rock Springs RMP and similar RMPs get enacted. And it's the future of Wyoming. It's the future of my kids and grandkids. And that's what this money's there to fight. And if it's more money that's needed, I'm perfectly willing to put more money towards it to fight this battle. Thank you, Mr. Chairman.
All righty. Did we vote on that amendment? All right. Sorry, I keep getting ahead of myself because I'm hungry. Apologize. All right. So anything else on the amendment? Yes, 50 million. All those in favor of the amendment, please say aye.
Aye.
All those opposed? All right, that amendment has been adopted. Back to the bill. Anything further on the bill?
Question.
All right, question being called. Katie, would you please call the roll on
Mr.
24
Chairman.
LSO 254?
Mr. Chairman, this is roll call for 24 LSO 0254 federal land use plans, legal actions authorized as amended. Senator French.
Aye.
Senator Hicks excused. Senator Ide.
Aye.
Senator Kolb.
Aye.
Senator Larson.
Aye.
Representative Alaman.
Aye.
Representative Allred. Representative Banks.
Aye.
Representative Conrad.
Aye.
Representative Davis.
Aye.
Representative Slagle.
Aye.
Representative Winter.
Aye.
Chairman Eklund.
Aye.
Co-Chairman Steinmetz.
Aye.
Co-Chairman Crago. 14 aye, 1 excused.
All righty, and with that, we are done with today's meeting schedule. The rest of us are going to go on a tour and we'll be back here tomorrow at 8:30. We are adjourned for the day. Thank you.